31st of August, and time to begin this hearing session. Can I first check that everybody can hear me? Any thumbs up, nods? Yeah, good.
Under action, yes.
That's a good start. So welcome everybody. This hearing relates to an appeal, reference ENVC-003-15 against a partial refusal of an application by Norbord Europe Limited to vary PPC permit PPC E002-0054 relating to the premises at Station Road, Cowie. My name is Stephen Hall and I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division. I have been appointed by the Scottish Ministers to determine this appeal. Could I start by asking the parties to introduce themselves, please? For the appellant first, Mr. Muir, are you leading for Norbord Europe Limited?
Yes, thank you, sir. Yes, indeed, I'll be leading, at least in the sense of providing some responses in the introduction to the questions that you've set out in the agenda. Of course, it may be that others will wish to contribute to the discussion thereafter. With me are Colin Bissett, instructing agent at DAC Beechcroft, Steve Roebuck and Stuart Lindors from Norbord, and Dr. Bernard Acton from Albany Consulting Group. I think, sir, you have affidavits from Dr. Acton and Mr. Lindors.
Yes, I do, thank you. And for SEPA, Ms. McGregor, are you leading for SEPA?
Yes, sir, I am. My name is Fiona McGregor. I am a solicitor within St Masons and I'm here today representing SEPA. I'm joined by Josephine Armstrong, who is an in-house solicitor within SEPA, Andrew Sullivan, who is the Senior Policy Officer within SEPA, and both Andrew Simpson and Callum McGregor, who are Environment Protection Officers.
Thank you. So I think we had a note that Gary Walker might be attending too, but I take it he's not joining us today.
No, sir.
Thank you for those introductions. I circulated an agenda for today earlier this month. Can I check that everybody's received that? Yep. Nods, that's good. And you'll see that under other matters, I seem to have failed to have numbered the later items on the agenda, but item 6, other matters, there's a bullet point there giving an opportunity for parties to raise any additional points that I've failed to cover in my agenda. Don't worry if there's something you want to say that doesn't seem to be covered by the main agenda points. You can input it then. We're obviously, hopefully, we're getting more used to working by video conference, and I hope you don't have any technical problems today. But we have Graham Mason on hand, who I think you've met already, from our IT team, and he'll hopefully help to address any issues if they do arise. In any event, could I ask you all to follow the usual practice of keeping yourselves on mute when you're not seeking to speak? And if any of the attendees aren't expecting to actively participate today, could I ask you to turn your videos off, please? To avoid people speaking over each other, I think it's best if people generally indicate their desire to speak by showing their hands and wait to be brought in by me. But if we're clearly in the middle of a two-way conversation, then that isn't necessary. And if I do fail to spot you and we appear to be moving on to the next topic, then by all means, speak up. I will be taking notes as we go along, so please keep things steady. A reminder that I don't have a background in environmental health matters, so another request to keep acronyms and technical language to what is absolutely essential. And I may ask you to pause from time to time to allow me to keep up with my note taking. If you feel we need to look at a particular document as we're talking, then please give its document number if it has one, and allow a moment for people to find it. I'll be working electronically, so it'll take me a second or two to bring things up on my screen. I'll look to break for lunch about 1 p.m, assuming we aren't finished by then. And we'll also have short comfort breaks mid-morning and mid-afternoon if necessary. Are there any matters anyone wishes to raise at this stage before we proceed with the rest of the agenda?
I think so. The only point was that my agent, Mr. Bissett, did circulate a speaking note that represents what I'm about to say by way of response to the agenda items, which I think was sent to the DBEA inbox to Mandy McComiskey and I think to others. So if you have that, so that would be helpful just for your note taking.
I don't have it. Was that sent just yesterday, or?
I believe it was sent yesterday.
Okay, it's not filtered its way through to me, but it's useful to know that it's on the way, so I can catch up with it when I see it.
And if there's an email address that it would be handy for us to send it to, we're happy to do that further just now.
No, I think it's best to go through Mr. McComiskey. As I say, I can pick up on it later. I can note down the main points of what you're saying now. Thank you, Mr. Muir. Anything else? Good. Then if we can go on to item 2, hopefully we can deal with this relatively briefly, just to make sure we're all on the same page as to what is proposed here. So I think probably if the most appropriate person from the appellant side would be in a position to briefly explain what it is that Norbord Europe does, how the WESP crumb is generated, how it comes about, and how it's dealt with now, and what the permit variation is seeking to allow. I don't know who the most appropriate person from the Norbord side is to give us a brief overview of that.
Will you? Sorry.
Yes, Mr. Muir, would you?
I'm happy to do that if that helps.
Yes, whichever. Just not in great depth, but just to set the scene, really.
Yes, and obviously by way of scene settings, you'll appreciate that the permit is issued under the PPC regulations, which I think you have an updated copy of, and that it's a Part A installation, and I set that out in the speaking note. But in terms of your question at item 2 and what it is, the principle and the operation of a wet electrostatic precipitator are described in what's called the 2016 Wood Panels BREF document, which you have a copy of. It's at page 149 of that document, PDF page 171 in the PDF of that BREF document, which was lodged, I think, by Norbord. And that's described then in paragraph 4.2.4.1. And as set out there, in brief, there are 2 stages to a wet electrostatic precipitator, the wet scrubbing stage and the electrostatic filter stage. In the wet scrubbing stage, pollutants in the crude gas stream are effectively washed out, including solid matter, principally wood fiber, and some soluble gases. And then in the electrostatic filter stage, further pollutants are plated out by electrostatic precipitation. These include superfine solid matter, principally wood fiber, with condensed volatile organic compounds, which are liberated when the wood is burned. And then periodic washdowns flush out the plates of the electrostatic filters. So these substances in the WESP end up in the circulating liquor of the WESP, as it's known, which is cleaned by means of a centrifuge mechanism. And the clean water is returned to the WESP for use as the wet scrubbing solution, and the separated sludge is removed as a semi-solid residue, which is known as the WESP crumb, the wet electrostatic precipitator crumb. So that's how this substance comes about. It has a very high calorific value, which of course is what makes it very suitable for use as a fuel. And the statement of appeal itself at paragraphs 3.4 and 8.6 explain that West crumb is used as a fuel at other Norbord plants. Dr. Acton's affidavit from the 28th of September last year refers to this at paragraphs 16 and 17. And I think so you also have the technical statement by Stuart Lindor as appended to his affidavit of the 1st of October. So in short, the West crumb is generated at the WESP that covers the particle board or PB production facility. And there is a process map which was appended to the technical statement of Mr. Lindor. So you have that PB1 process map to show you at what point in the process it's generated. And the WESP itself, the wet electrostatic precipitator, is a directly associated activity at the site. And we see that on page 8 of the permit, the consolidated permit, at condition 1.1.5.13. And
sorry, could you give me that reference again?
1.1.5.13 is the condition in the permit that specifically mentions the WESP as a directly associated activity. As far as the WESP being best available technique, that's explained on page 2 of the technical statement from Mr. Lindor's. And in effect, without this technology, including the WESP, the site simply wouldn't be permitted to operate. And the technical description, as I say, is in his statement. And the permits conditions applying to the particle board one line WESP are set out in condition 6 at pages 32 to 36 in the permit. Under condition 6, conditions applying to PB1 line heat generation and wet electrostatic precipitators. So that's that's what the crumb is, how it's generated, and how it's an integral part of the activity at the site and is covered by the conditions in the permit.
So you just to be clear, you described there are two parts to the generation of the crumb. First, the washing out element, and then the electrostatic element. But both the residues from both these two processes end up in the same place.
Yes.
Yeah, that's good. Thank you.
Would you like to say how it's currently dealt with briefly, which is your next question?
Well, let's briefly allow SEPA in just to check that there's nothing you've said goes against their understanding. Mrs. McGregor?
There are 4 points that I want to make, and then I'll open it to Andrew to see if they have anything to add. But the 4 points I wanted to make were in terms of what is the West crumb. So first of all, my first point is that it comprises woody material, VOCs and heavy metals. So it's a mixture. The second point I wanted to make, and this is perhaps just me not being familiar with the process, but when I read the word crumb, I had in mind, cake crumbs or bread crumbs or something quite dry. It's not dry, it's wet. And although it goes through a dewatering process, it is still a very wet product unit. But in terms of moisture content, we are looking at around 59 to 69% moisture content. And just to give you a comparator, I'm told that a typical biomass will have around 15% moisture content. So it is a very wet article. The third point just to make is that West Crum will not burn on its own. And our understanding is the calorific benefit will be impacted by the drying of the moisture content in the wesp. And then the final point just to raise was there are actually two types of West Crum. There are two production lines at the installation, one for particle board and one for MDF, and both production lines result in a Wesp Crum. And it wasn't entirely clear on reading the documents what this variation referred to. The original application lodged by the appellant seems to appear to cover both types of Crum, but we noticed as we were going through the appellant's submissions, and I think Mr. Muir referred to it there too, they only seem to refer to laterally to the particle board Crum. And so I think it's important that at an early stage we identify what it is we're talking about. Is the variation for both, or is it just for the particle board?
Absolutely, yes. Mr. Muir, is that point you can clear up?
Yeah, yes, my understanding is it is now restricted simply to the particle board, but perhaps the Mr. Lindors can just confirm that.
Yes, it will only concern the PB West Crum. The MDF Crum we've removed from this appeal process.
So I hope that's clear. It is only the particle board Wesp Crum.
And is that changed then? Is that changed from when you made the original application?
I think it may be a change from the original application, but not, I think, from the original appeal.
And do I have it within my power to change the nature of what is proposed in this way?
There was originally proposed both West Crums, but we decided purely to go for the particle board West Crum, which is the highest volume of West Crum we generate on site.
I think that was the case before the statement of appeal was lodged. I think this was something that was covered quite early in the process. I think Mr. Roebuck maybe.
Mr. Roebuck?
Yes, I can confirm that. Very early in the process, and the SEPA's solicitor says the two materials are quite different. We are dealing with a PB West Crum, which has much higher solids content, and biomass generally. The statement was made that biomass has typically low moisture content. Wood is 50% moisture, so virgin wood contains 50% moisture. I will not dispute that wood is biomass.
I suppose I'm coming back to the point about the potential change in what's being applied for here. In the event that I allow the appeal, I could always impose a condition limiting it to, just for the sake of avoidance of doubt, I could include a condition limiting it to just the particle board West. Ms. McGregor, coming back to you, I think your third point, where you said that you were making the point that the West was wet and that it wouldn't burn on its own. And then I think you said something about the calorific content would be affected by the drying process. Is the point there that the overall effectiveness of the combustion at the plant would be harmed by including the West Crum element because it's so wet, and that a lot of the heat generated by burning the other material would be required to dry out the West rather than actually producing the heat and power? Is that the point that was being made there?
Yes, although Andrew might be better placed to explain that than I am.
By all means.
Hello, Mr. Reporter. Yeah, our understanding is that the West Scrum does have a high moisture content, higher than a typical biomass, which it's trying to be compared with, which would normally be reported at around a 20% moisture content for efficient combustion. I wouldn't dispute Mr. Roebuck's point that a fresh wood may have a 50% or higher moisture content, but reality is when you want to burn this stuff for calorific benefit, it has to be a lot drier, and the West Scrum certainly is not.
And so, in Mr. Simpson, in your words, what are the implications of that then?
The reality is that the perceived benefit of mixing this material in with the other biomass on site, which is dry, is that it won't necessarily provide a calorific value, a calorific benefit to that.
Okay, so why do you think Norbord wants to do it?
It's a disposal route.
Well, I wonder if Mr. Lindors can perhaps assist me, sir, in responding to that point. The blending is a matter that I think Mr. Lindors and Dr. Acton both comment upon. So it may be that one or other of them.
Yes, I'll allow that. We're probably getting off the agenda slightly, but I introduced the question, so I think I should give Mr. Lindors an opportunity to come back.
We have numerous sources which we use in the heat energy plant. The design of the heat energy plant is a three-stage process. The initial part is a drying process. So whatever the moisture content is, the equipment is designed at its first phase to dry the biomass. We drive the moisture of the biomass prior to going into the combustion section of the equipment. If the material is too dry at the initial stage of combustion, it will flash off. So we will not get the benefits once it moves further into the combustion process. So if we put purely dry material in, there is a possibility we'll get very high temperatures at the initial drying phase, which could damage the equipment. And once we go further into the combustion process, we will not have the fuel available to generate the heat. The drying of the biomass is an integral part of the design of the heat energy plant.
So are you saying that the wetness of the West Scrum is a benefit because it's helping to achieve the ideal moisture content, and if the other material is too dry? Yes,
if all our fuel sources are blended, and I can't tell you exactly the moisture content on entry into the heat energy plant, but it has to be wet. I think that's the simplest way I can put it, if not because that will defeat the purpose of the equipment design, where there's an integral part as the drying process. Too dry a fuel causes problems, as does too wet a fuel, which is why we blend the various streams of biomass on site.
Do you have any problems at the moment with the fuel source being too dry?
No, because we have the biomass which we blend comes from various sources, but we also have drier biomass, which is reject material from the MDF process line. So this has been through the original drying process and preparation of the MDF fibre to produce a board. If we have to reject the fibre prior to the pressing process, that is automatically directed to a silo, and then that material is blended with the other biomass, which we blend which we blend at that process. That other biomass could be Esmo cake, scrap board, pal fines. That's the blending for the external preparation, but that is blended with the dry material which is rejected from the MDF production process.
So, Mr. Simpson, do you have any reaction to what Mr. Lindors has said there?
Mr. Reporter, I can't dispute the operational requirements for the combustion plant on site as specifically as Mr. Lindors has said, but only that in comparison to a virgin biomass, this material is very different. That's the point we've tried to raise, and we feel that was maybe missed in the initial description of the material.
Okay, thank you. Let's move on to the next one. Sorry.
Sorry, could I just make one point there, just to Andrew mention virgin biomass. The material that we manufacture MDF from is virgin wood. So any of the reject fibre from the line or from the refining process is reject wood, is virgin wood.
Mm-hmm. Okay, thank you. So I think that discussion was coming as the first bullet point on item 2. Mr. Muir, do you want to go on and deal with the second bullet and how the West Crumb is currently dealt with?
Certainly. So the current disposal of the West Crumb is described on page 4 of the technical statement, which Mr. Lindors, which Mr. Lindors prepared, and that I think was document 6, submitted with the original statement of appeal, at the moment, the disposal is also, I think, described in detail in Glenn Campbell's affidavit of the 30th of September last year, which describes the previous disposal to landfill, and since June 2018, the disposal in bulk containers from Cowie down to the only supplier identified as having a disposal service for West Crumb if it is being treated as waste, and that's in Southampton. So Glenn Campbell's affidavit describes in detail, and it probably isn't helpful for me to read that out to you, sir. But that disposal is in essence because Norbord at that time hadn't identified a technical means of using the West Crumb in the production and combustion processes at the plant. I understand there were attempts to use small amounts of it in panelboard production, but there were quality control issues there. And I think so you'll be aware from the documents that there's an obligation on the permit holder Norbord to seek to use as far as possible within its production and combustion facilities any substances that are generated in the course of the production. So there's an obligation to seek new ways to use the substances that are generated and to minimize waste. And it's in that sense that Norbord, just as others, seek to find an appropriate use for the substances. And I'll give you, sir, the reference. It's a condition 2.6.1 in page 15 of the permit, page 15 of 68, under the heading Resource Utilization. So in essence, at the moment, the West Crumb is packed up and taken to Southampton, where it is destroyed. It's incinerated at Southampton, and the economic costs of that are set out in Mr. Campbell's affidavit. And I think the annual cost is somewhere estimated a little over £500,000 a year. I think in that affidavit, if I'm right. And obviously I can cover briefly the third bullet point here, which is what the permit variation would allow, and it would simply allow the West Crum to join the other fuel sources, which are already permitted for use in the heat energy plant, and that's at table 1.3 on page 7 of the permit. That's the table that sets out the different combustion units and the fuel sources which may be used in those production units.
Thank you. I just had a couple of questions. Can you give me an idea of the overall, perhaps this is for Mr. Lindors, the overall tonnage per year or volume per year of West Crum that is being talked about here?
We're estimating 1,300 tonnes wet, which in reality would be 650 tonnes dry if we're looking at 50% moisture content.
Sorry, was that 1,500 tonnes wet?
1,300 wet.
And then 600 tonnes dry.
I'm sorry, I was muted there. It would be 650 tonnes dry, assuming 50% moisture content.
Okay, but you'd never be able to get it down to 0% moisture, would you?
That would affect, as I previously mentioned, the drying stage of the heat energy plant. So we'd be the 50% moisture content, as Mr. Roebuck had pointed out, is probably standard for wood. So we're looking at normal standard moisture content.
Okay, my other question was just to clarify that the shift to the sending of the West Crum to Southampton came about because it's no longer possible to dispose of West Crum to landfill. Is that correct? That wouldn't be allowed now.
Wouldn't be allowed due to organic content. There is we do certain tests called the waste acceptance criteria, and from that there's certain parameters we check. One of these is loss of ignition, and I think it's total carbon content. Now that reflects on the amount of organics which could cause leachate at the landfill site. So the reason we were prohibited for going to landfill was due to the organic content of the West Crum.
Good, thank you. Ms. McGregor, any comments on these bullets?
Well, firstly, we agree that it's no longer sent to landfill because it's regarded as unsuitable due to total organic content, loss of ignition, dissolved organic compound. And we also agree that it's sent off for disposal to the high temperature incineration site in Southampton. The only point we wanted to make there is that Southampton is not the only high temperature incinerator in the UK, and that may or may not be relevant when we come on to consider some of your later questions. There are other licensed high temperature waste incineration facilities, and I have it noted that there are 4 in the UK, 1 in Cheshire, 1 in Kent, and 1 in Middlesbrough. Now, obviously, I have no information as to why Southampton has been chosen, but there are others. Southampton isn't the only one. And in terms of what the variation would allow, I would agree with Mr. Muir's assessment of that. The only point again to make is that if the variation is to be allowed, it should be restricted to the particle board WESP.
And why is that?
As I understand it, although I'm happy to be corrected by someone on SEPA's team if I've misunderstood, when the trial was being undertaken, the WESP that was generated as a result of the MDF production process, when it went through the trial, it generated higher levels of emissions, lead, and so that trial was stopped, as I understand it, at a very early stage due to the results from that particular article, that WESP. And so the concerns, although SEPA has concerns in relation to the WESP from the particle board production line, those are even more so in relation to the MDF WESP.
Thank you. Mr. Lindors, do you want to comment on the availability of these other potential incineration plants that are perhaps closer to you than Southampton?
I believe the company we use at Southampton own the plant in Middlesbrough. I previously looked at an incineration facility in Dundee. However, I do not, what I was told, they could not accept that type of waste due to their SEPA permit. It's an incineration for energy plant, I think it's in the south side Dundee. So we have looked at other options. However, that's waste incineration, and that is not the main part of our appeal.
Yeah. Good, thank you. Shall we, anything else anyone wants to say on item 2?
Yeah, if I, is Bernard Acton, can I just speak a second there?
Yes, by all means, Mr. Acton, yes.
Just two things that seems to be a bit of unsurety just been said. Number one is this: the organic content of the West Scrum and the other descriptors that's the SEPA mentioned there. They are the reasons it's not going to landfill is because it's fuel. It has combustible content. You can't put wood, any type of wood going into land is frowned upon. It should be going to use its calorific value. So the reason it was not allowed into landfill historically is because of, as I say, its calorific value. And I think that's a point that needs to be emphasized. And the second thing is, I just don't understand why SEPA are looking at referring to high temperature incineration for West Scrum. There's no pollutant in it that requires high level incineration. I just don't understand that reference at all. Somebody seems to have some misunderstanding.
I'm just seeing if we're going to cover this later on, but you've raised it. So can somebody from SEPA, Mr. Simpson, do you want to?
I'm happy to come in there, sir, if that's okay.
Mr. Sullivan, yes.
Thanks. So the reason that it wouldn't be able to go to landfill is not because it has a combustible content. Lots of wastes which have a combustible content. For example, your grey bin outside your house, which has a combustible content and is a kind of is a waste stream that is routinely incinerated, also goes to landfill. This is classified by Norbord as a hazardous waste, and so it goes so it can't go to normal municipal waste landfills. It could go to a special hazardous waste landfill. And this is what Mr. Lindors has referred to, the waste acceptance criteria, which apply at hazardous waste landfills, which this material doesn't meet. So that means that due to its classification as hazardous waste and the fact that it doesn't meet the hazardous waste landfill waste acceptance criteria, that means that landfill is not an option. It's not because of its combustible content. Lots of waste streams which have combustible content go to landfill. And that's why we're seeing a move towards incineration for your municipal grey bin waste. But that's not to say that it's banned because of its combustible content.
And it's classed as hazardous because of its heavy metal content.
Well, yeah, because of these things, Norbord have classified it as hazardous waste. So that takes us on to the high temperature incineration question, which was just raised.
Right. Okay.
So
can I come back on that one?
Could I finish, please?
Yeah. Okay.
Let Mr. Sullivan finish. I'll certainly come back to you, Mr. Acton, after Mr. Sullivan's had his say.
So again, for hazardous waste, there's the incineration facilities which are appropriate for most hazardous wastes operate at a temperature of 1100 degrees C instead of 850 degrees C, which is normal for a municipal waste incinerator, such as the one at Dundee. So the one at Dundee is not allowed to take hazardous wastes because it doesn't have the appropriate operating temperature. That's why it's limited to these specific facilities, which all unfortunately exist in England. We don't have any high temperature hazardous waste incineration capacity here in Scotland. So
is that just a regulatory quirk then, if you like, that this particular waste is classed as hazardous? Another regulation says that hazardous waste must be burnt at high temperature. But if I've understood Mr. Acton's argument correctly, the reasons why you normally would burn hazardous waste at a high temperature don't apply to this particular waste.
Well, I suppose it's I don't think I would call it a regulatory quirk. I think the Industrial Emissions Directive is very clear that hazardous wastes should be burnt at high temperatures to ensure complete destruction and can be managed in a way which has all of the appropriate abatement equipment, emission limit values applied to it, and the continuous and periodic monitoring associated with that full range of potential pollutants that's present in hazardous wastes. It makes that distinction between the two classes of waste and the operating and performance requirements of those specific plants.
Okay, thank you, Mr. Acton.
Okay, I don't disagree with what Andrew has said there. What I was trying to say was the fact, my understanding is the sites that Norbord originally tried to take the landfills, the West Crum to landfill to, they were refused at that site because of the calorific value. I'm not arguing with Mr. Andrews' overall descriptions of waste types and that type of thing, but the site that was available to Norbord couldn't accept it with their waste license restrictions because of its calorific content. That is what I understand to be correct. The second point is that the contaminant that's being referred to in the West Crum, lead, doesn't benefit from high temperature incineration. That is all I was saying. I was just making sure everybody was clear on that. The 2 points are correct, but the reasons are, I think, different than what SEPA have put in their text to this inquiry.
Okay. Thank you. Yes, Mr. McGregor.
Sorry, sir. There was just one point that I to raise. It may not be of any particular relevance, but in relation to your question about how the WESP is currently dealt with, SEPA just wanted to make you aware that when they were on a site visit in July, they were advised by the on-site staff that there was an attempt, or Norbord are trying to reincorporate the WESP back into the feedstock for the production process. Now, SEPA didn't have any more information than that. They've asked for further information about what that involves and how that's being done, but I just wanted to raise that as of July, that's what SEPA had been told.
Thank you. I think perhaps Mr. Lindors touched on this earlier, that this had been attempted. Is that right, Mr. Lindors, that you?
They are attempting that on site, but it's a limited volume, and the concern the site would have is on the board quality. It's not a guaranteed route for us to use PB Westcrum. And as the operator, we have to look at different options. This is one we've tried at the moment due to the major issues we have with transporting the Westcrum to Southampton, because we have to have allocated time slots, volume slots. So we're actually having to stockpile Westcrum on our site. So we have attempted this process of reintroducing limited amounts into the production process. And when Mr. Simpson was on site, I explained that to him, basically saying we were only doing it in the interim, but as a company, we have to look at all options.
Thank you. Right, should we move on to item three then, or Mr. Muir, did you have one more point to make?
Well, perhaps coming on to item 3, but in a sense, just making the point that obviously the question whether it's waste at all is in a sense the key one. Is it a waste or is it a byproduct? Because the fact it's been treated as waste to date doesn't mean that it's going to be waste going forward. And I've set out in the speaking note whereabouts in the materials we see that, for example, in Article 7.1 of the Waste Framework Directive, speaking about the list of waste, the Waste Framework Directive is clear that the inclusion of a substance or object in the list shall not mean that it's waste in all circumstances. A substance or object shall be considered to be waste only where the definition in point 1 of Article 3 is met. In other words, it's a substance or object which the holder discards or is required to discard. So it was just to make the point, as the speaking note does, that the very fact that something may have been a waste in other circumstances doesn't mean that it is always a waste. You have to look at the specific circumstances. In this case, the circumstances of the application. But that's perhaps not a controversial point, but it's important in legal terms, let's put it that way.
Thank you. Well, do you want to go on to item 3 then? And say I haven't received your speaking notes, but if you'd like to go through it.
Surely. Well, just on the legal framework, certainly it's accepted. This is an application for a variation notice under Regulation 46.3 of the PPC regulations, and Regulation 58 and Schedule 8 apply to the conduct of the appeal being made under Regulation 58.1b.
If I could just interrupt there, my appointment to this appeal is actually under Section 114 of the Environment Act, which means that Scottish ministers have delegated the decision in this case to me.
Yes.
And I think that brings in Schedule 20 of the Environment Act, as being the schedule that applies to the holding of inquiries and hearings in this case. I don't think it makes any material difference to what we're discussing today, but I'm just aware after I'd issued the agenda that I'd referred to Schedule 8 of the PPC regs, but I think Schedule 20 of the Environment Act also does apply. But sorry for interrupting. I'll let you continue now.
Thank you. We're asked, I think, about the 2017 amendments to the PPC regulations. I think that may be a reference to the Pollution Prevention and Control Scotland Amendment regulations in 2017, SSI number 446. If that's the case, then I don't think those amending regulations are of direct relevance to the present case.
Good. That's helpful. I just saw that they existed, and I was as always, it's difficult to as a layman how to fit amendments into the original regulations. But if I know that I can put them to one side, that's very helpful. Thank you.
I think I should say I think the version of the PPC regulations which we've provided is a consolidated, up-to-date version.
Right.
So,
good.
It will include all of the amendments up to the start of this year. You also ask under question 3 about the applicability of European publications, including the European directives. In essence, the European law is retained under the provisions of the European Union Withdrawal Act 2018, as amended. Secondly, the European Union Withdrawal Agreement Act of 2020, and the UK Withdrawal from the European Union Continuity Scotland Act 2021. The first two are acts of the Westminster Parliament. The third is an act of the Scottish Parliament. And in essence, the effect of those acts, as I'm sure you're aware, is that the law of the EU as pertaining to waste is, as at 11 o'clock on the 31st of December last year, is retained, including the impact of the directives. Obviously, the directives were transposed into domestic law, and that's why we're looking at the PPC regulations. So, in a sense, one's first port of call is with the domestic law, but the law as a whole has been retained under those 3 acts. And EU-derived domestic legislation, such as these PPC regulations, continue to have effect in our domestic law after the end of the implementation period by virtue of Section 2 of the European Union Withdrawal Act 2018. And I've set that out in the note, but I hope that's not a matter of controversy between us at present.
So you see that the 4 conditions that we'll probably spend most of today talking about, they are contained in the Waste Framework Directive, but they're still a part of domestic UK law due to the contents of the EU Withdrawal Act 2018.
Yes.
Right. Thank you.
And then I think the last question to address under your point 3 was the relevance of case law, and in essence, the principle of the supremacy of EU law that we were used to as members of the Union continues to apply by virtue of Section 5, subsection 2 of that 2018 Act. And case law is covered by Section 6 of that Act. In essence, the case law remains relevant. It might even be binding if it's directly in point, but of course, the present Waste Framework Directive dates from November of 2008, and member states were required to bring into force their laws necessary to comply with it by December of 2010. The Waste Framework Directive was amended by Directive 2018 in May 2018, and there's reference to that amendment, I think, in the statement of appeal and our further response. And we've given the consolidated version of the Waste Framework Directive, which identifies when particular amendments were made. I think the 2018 amendments are identified by the code M4 in the consolidated version. The key point is that it was in 2008 that the Waste Framework Directive had this new Article 5.1 about the key distinction between waste and byproducts. And that is where the text of the law is for our purposes. Case law, which dates before that directive in November 2008, may cast light on the principles that were then in effect written out into the law in 2008 in legislation, because Article 5.1 draws upon the case law of the European Court of Justice prior to that date. But the key text is the text that we find in Article 5. It's not the text of the case law. And of course, later case law has the advantage of being decided against the backdrop of the 2008 text, rather than being case law that was decided under the 1975 version of the Waste Framework Directive. So yes, all of the case law may have some relevance, but the more recent case law has the advantage of being decided against the latest version of the directive.
Yes, that's helpful. That's really what I was getting at. That it's quite interesting to see the pre-2008 case law and how it fed into the text of Article 5.1. But now that we have Article 5.1, to some extent that has presumably reset the dial. And so in terms of how I use my time, it might be more useful not to spend so much time on the case law and studying in too much depth the case law before 2008, because really it has been found expression in Article 5.1.
Yes. I think that's all that I would say about your point 3 in the legal framework.
Okay, thank you. Mr. McGregor, do you agree with all that?
Yes, I don't take any issue with anything that Mr. Muir has said. Just one point in relation to the 2017 amendments, just for your information, sir. The amendment regulations in 2017 inserted provisions relating to medium combustion plants. And because this is a large combustion plant, those amendments aren't of any direct relevance.
Thank you. Right, I don't think I had any further questions on item 3. So if nobody else has anything further to add, we'll move on to item 4, which is a sort of more, I suppose, more broad-based approach to the scope of what we have before us today, and how much my role should be limited to this narrow, I suppose, technical question of whether the West crumb should be defined as waste or byproduct. In reading the evidence, various other arguments are coming in around which are of interest in themselves, around important matters like promoting the waste hierarchy and minimizing greenhouse gas emissions. But I suppose I'm interested in people's views as to really how much weight I need to give those arguments as compared to the more narrow, I suppose, technical legalistic question of whether this is a waste product or a byproduct. Mr. Muir, if I could come to you first on that, please.
Certainly, sir. Just on the first question, the technical question, whether it's defined as waste, perhaps no surprise that that the appellant sees it rather that the question is whether it's a byproduct rather than whether it's waste. But because that's the obligation under Article 5, that that member states need to ensure that where the conditions are met, their law will recognise byproducts as being such. So I think for this appeal, the question is whether the West Crum, on the basis of the application being made for use as a fuel source in the heat energy plant, is a byproduct. And that, in a sense, is a question of mixed fact and law. Depending upon the facts, then it will fall under, as Norbord sees it, then it will fall under the definition of byproduct set out in Article 5.1. As far as the other arguments, waste hierarchy, minimizing greenhouse gas emissions and so forth, they are relevant in this sense, and this is the reason why Norbord points them out. They're relevant because they are, of course, part of the legislative intention behind the provisions that are made in Article 5.1 of the Waste Framework Directive as amended, and that's why the recitals to that directive are relevant. In understanding what any legislation means, we need to know the legislative background, and it is because of the waste hierarchy, minimizing greenhouse gas emissions and so forth. It's because of that that the institutions in the European Union legislated in this way. And so they're mentioned because any failure to interpret and apply the legislation correctly may mean that the policy aims of that legislation are not achieved. So these factors, these important policy factors, are not going to help you, sir, with the facts of the case, but they do, in my submission, help us with understanding the purpose of the legislation and what it is intended to achieve, and that is why, of course, the Scottish Minister's policy includes the waste hierarchy and preventing waste where at all possible, and finding uses for substances so that they are not discarded in the way that the definition of waste describes. So that's why those points are still of relevance.
Thank you. Ms. McGregor, your comments on these points.
Yeah, only a couple of comments from us in relation to your first question. The answer to that is yes, but as Mr. Muir did, there are probably a couple of clarifications to that. I think we agree it's both a factual, technical question and also a legal one. And then the other point we wanted to make is one that Mr. Sullivan raised earlier on. Our position, it's not just a technical question. It is important to get the classification correct so that we can apply the correct regulations and control for the protection of the environment. As we see it, you can't distinguish getting the definitions right from the environmental protection principles. The different definitions are there for a reason, to ensure that in particular scenarios, the environment is adequately protected. So I guess there was just that concern from our side about the use of the word technical. We are not being overly technical here. It's very important that we consider the definition in detail to make sure that what we apply are the correct environmental controls. And then in relation to your second question about are the arguments regarding promoting the waste hierarchy, minimising greenhouse gases of limited relevance, yes, we do agree they're of limited relevance. In relation to the point that Mr. Muir just raised there, I think I would point you back to SEPA's response of the 31st of May, where it dealt with the waste hierarchy and the appellant's submissions in relation to those. And I probably wouldn't do it justice by summarising that here, so I would just commend you read that in relation to that point.
Thank you. Any further points to make on the item 4? Okay, and that's 11:05. I think we'll have a wee break there. We come for break, and we'll come back at 11:15, please. Thank you.
Yeah, I can hear. What? Hello. What about on the WebEx? Yeah. Yeah, I've just put myself back in the WebEx. I can't unmute. Yeah, I'm going to do that, but I can't unmute on yours. Colin, I'll send you a text.
that's 11:15. If people are back with us, I see Mr. Muir, Ms. Armstrong. Good. I think that's most of us back. So if we can come on to item 5 then. We're getting into the meat of it now, I think. So this is coming on to the 4 conditions set out in the Waste Framework Directive for determining whether a substance is a byproduct or a waste product. And the first of those is whether further use of the West Frum is certain. I suppose in all of these, I'm assuming that we're to approach this question based on the scenario that the permit variation is allowed. So the question would be, would further use of the West Frum be certain if the permit variation was approved? But you'll tell me if that's wrong. Mr. Muir, I should also say, Mr. Muir, I received your speaking note, so that's come through. That's come through fine. But I'll still ask you to summarise your position on this point, please.
Thank you. If I could just have 1 second.
Yeah, by all means.
So this is at 5A, I think, in the speaking note. So yes. I'll follow that, and we can pick up any points as necessary. But on this particular point, SEPA has accepted that if permitted as a fuel source, the further use of the West Frum is certain for the reasons that were set out in the grounds of appeal at paragraphs 3.1 to 3.3, and therefore the first condition would be met. And I think in 31st of May this year again, it's only conditions B and D that SEPA refuses. And certainly, my submission would be that at this stage in the process, where we've proceeded on that basis, it would be somewhat unfair if this were regarded as somehow not met. And obviously, I stand ready to assist the reporter on that. But my understanding is that this is accepted, and I've made a reference back to the Commission guidance at paragraph 1.2.3, but I've reminded you, sir, about the compelling case that we have here for its use. It meets the requirements of the permit conditions. It avoids costly disposal in England, and that will be true wherever, I suppose, in England it had to go. The substance is already used as a fuel source at the appellant's other sites where West Frum is used, for example, at Inverness. So there is the reassurance that this is a company that has followed through by seeking to find uses under its permits for precisely this substance at other sites. And as explained in the technical statement and the affidavits, it contributes to the fuel mix for the heat energy plant. And in my submission, that is sufficiently certain for the case law. And crucially, of course, the West Frum is definitely not a substance that the appellant wishes to or proposes to discard. And I've referred to paragraph 4 of the response on the 25th of January, where, again, we've made certain submissions about certainty. And that's at paragraph 4.1 in Norbord's response dated the 25th of January. And I won't read all of that out, but that's where you will find the sort of detail on that point. I've referred also here to paragraphs 12 to 18 of Glenn Campbell's affidavit, which I think is document 8, that was lodged with the statement of appeal. And that's where the economics are set out and the strong financial case for use as a fuel source. and also to page 4 in Mr. Lindor's technical statement on the 1st of October. In a sense, of course, this very application and appeal demonstrates the desire on Norbord's part to use it. I don't know if you wish me to go through your other questions under point 5 before moving over to SEPA, or are they sufficiently divisible?
I think we'll break it up and we'll go to SEPA. I mean, I think I take the point. I also took from the submissions that they accepted that this condition had been met, but we'll find out from if Ms. McGregor can confirm that in a moment. But I suppose I'm proceeding on the assumption that I also need to satisfy myself, regardless of SEPA's position. And that, that may be very easy for me to do, but I think I probably do need to go through the process in my decision of ticking off this condition as well, which is why I put these questions on the agenda.
Absolutely, but obviously, if there are specific points that you wish to raise that we can either come back on today or in writing afterwards, we're happy to do that. Just to make sure that we have the opportunity to put forward anything that may be troubling you, sir, on this point.
Yes. I suppose it's in my common reading of the word certain is as I say, a very high bar. But it seems from from your evidence really that I'm, and perhaps taken from the case law, and it must be, because I mean there's not, as I say in my second bullet point there, how far is anything in life ever 100% certain? That the way I'm to interpret that word perhaps isn't as strictly as one would normally do so in everyday conversation. And if considerations of high likelihood or desirability or desire of the appellant to do it are all powerful arguments that point towards the meaning of certainty in this context, I take it that's the argument that you're putting.
That's what the case law tells us, but I'm happy to deal with this paragraph by paragraph. So I'll wait.
Well, I'll go to Ms. McGregor then for your initial thoughts on this.
Excuse me, sir. I'm sorry to interrupt Ms. McGregor before
yes,
she
Mr.
starts. Dr. Acton apparently has had difficulty being readmitted to the call. I wonder if
I've been done. I've been let back in.
You're back in. Thank you very much. I'm so sorry to interrupt. Thank you.
Right. Hello, Mr. Acton. Hopefully you didn't miss anything too important.
No, I could hear, but I couldn't see. But we're on again now.
Right. Good.
Thank you.
Ms. McGregor, then, your initial comments on this item, please.
Sir, the first point is that we agree that as this is now a matter with you, you need to be satisfied that this test has been met. However, I can confirm that SEPA accepts that if permitted as a fuel source, then the specific use of West Crum in the heat energy plant is certain. That's based on a specific assessment of certainty based on use within the plant. Now, it's not a blanket acceptance. If matters were to transpire and the material were to be dumped or stockpiled in a shed with very little prospect of use, then SEPA might review that position. But based on what we have been told by the appellant and the particular use to which it is being put, then we are happy to accept that the West Crum is certain. Use of the West Crum is certain.
Thank you. Mr. Muir, then, did you have further points you wanted to make on the later bullet points under this item?
It was really, I think, your other questions, sir,
yes.
Which I've labelled as 5.2, 5.3, 5.4. So 5.2, how strict? Well, you already made the point that there's no absolute certainty in life, but of course, and I entirely take the point that Fiona McGregor's just made. Obviously, in the present case, the entire purpose of the application is to permit it to be used as part of the fuel mixture, and I've given reference to specific paragraphs in case law, the SAPI case, where the language said a high likelihood of reuse was sufficient, or in the Palin Granite Oil case, where there was a financial advantage to the holder of the substance to reuse it. The likelihood of reuse is high, and therefore, in that case, the court said, in such circumstances, the substance in question must no longer be regarded as a burden which its holder seeks to discard, but as a genuine product. And similar point is made in the Sati case, paragraph 37. So that helps us to understand where the EU institutions see the bar, if you like, and why it is that that you need to look at the circumstances. So I think all of that is supportive of certainty in the present case. And then there were two other questions or three other questions I think that you raised. 5.3 about the fact it's being sent currently to Southampton for burning, and is this further use? And I simply make the point here that the present destination of the West Crumb doesn't indicate anything about whether it is or is not a byproduct. Because of course the question is, if it's to be used as a fuel source in the heat energy plant, does it qualify as a byproduct? And Article 5 is intended to ensure that where a substance meets the 4 criteria, then it's not to be considered waste. So the fact that somebody treats something as waste at one point in time doesn't tell us that at another point in time and under different circumstances, the point is the substance is waste. And certainly discarding it for disposal in Southampton is not, in my submission, a further use of it by Norbord. And perhaps that also fits in with the next question about previous disposal to landfill, and whether that implies that it should be considered a waste product. And again, of course, prior disposal in a particular way doesn't tell us that it cannot be a byproduct. Otherwise, Article 5 would be defeated, and condition 2.6.1 of the permit would be rendered otiose. That's the condition that I referred to earlier, sir, which requires operators to seek to change their technical processes to prevent the generation of substances that they cannot use, and to find uses for substances that they may previously have discarded, so that they cease to be waste and are found as byproducts. I've referred to Dr. Acton's affidavit of the 8th of January. And as I say there, the whole purpose of the application is to enable use to be made of the West Crumb, and hence to cease the generation and disposal of waste. So the question is not whether the holder to date has discarded West Crumb, but whether under the proposal set out in the application, West Crumb would fall within the definition of byproduct. I think that's really everything that I wanted to say about the question of certainty of use, the first condition.
Good, thank you. I've got no further questions, I don't think, on this item. Ms. McGregor, anything further to add?
Just a couple of minor points. We agree with Mr. Muir. It's very difficult to ever be 100% certain, but what we have done here is applied certainty of use on a batch by batch basis, and that ties into what I was saying before. The appellant has provided evidence based on the specific circumstances of this application, which allows us to determine certainty, but if that were to change, the stockpiling example I gave, then that would be reconsidered. It's not an umbrella approach, it's very much a batch by batch approach. Your third bullet point, West Crum does it sent to Southampton for burning. Does this amount to further use? Our position is no. I think we are in agreement with Mr. Muir on that. It doesn't amount to further use. Your fourth bullet point, West Crum is said to have previously been disposed of to landfill. Does this imply that it should be considered as a waste product? I don't think there's too much between Mr. Muir and I in relation to this, but just to be clear, the fact that it goes to landfill itself isn't determinative. The actions of the appellant to date have been to discard the West Crum, whether that goes to landfill or to incineration. And there are, in relation to the incineration point, there are 5 points to note. First of all, it's transported as a waste. The waste regulation is applied to the transportation of the WESP. It's going to a specialist facility regulated under the Waste Framework Directive. That facility is an incinerator, and they are paying a third party to take it as waste. The third party isn't purchasing it as a fuel. So the past intentions have been to discard the material, and that we say would allow it to be classified as waste. However, we do accept that taking a batch by batch approach to certainty of use doesn't prevent the appellants from meeting the condition of certainty of use now. It could, provided that all the conditions for a byproduct are being met, it could now be classified as a byproduct. So I don't think there's too much as between Mr. Muir and I there. I think we are in agreement. Well, my position, it has been discarded in the past, and it therefore is classified as a waste, but that doesn't prevent it from being held to be a byproduct in the future, taking the batch by batch approach that I have described.
Thank you. I just missed a couple of points there. You gave five. You went through 5 bullet points, I think, of reasons why its transportation to Southampton would have been waste. It could be classed as waste in those circumstances. So I've got it's transported as waste. It's going to a specialist incinerator. They're paying a third party to take it, but you went on so fast I couldn't get the other two. So you just
my apologies. So the other two were waste regulation is applied to the transportation of the WESP. So when it's being transported, it's still regulated by the waste regulations. And then the fifth one is it's going to a specialist waste facility regulated under the Waste Framework Directive.
Thank you. Right, any further points to make under A then?
I don't think so, sir. The last points, the points, the way it's been treated previously, as I say, is because it was being discarded. But the point is, it's now to be used as a fuel. So on that basis, I think we're
because something is once waste, it's not always a waste. Yeah. Well, let's go on to. Sorry, Mr. Acton, was that?
Yeah, I was just trying to give some comfort to SEPA with this idea of it not always being used, having to be stored. If we look at Inverness, where SEPA allows West Crum to be used as fuel, it's the same product, the same calorific value, the same moisture content, and it's used continuously, successfully at Inverness. So why should it need stockpile or batching at Cowie? Thank you.
Thank you. Are we okay to move on to item B then? 5B?
Sir,
Mr. Gregor, yes.
I wondered if it was just worth at this point addressing the Inverness issue, and I don't know, Mr. Simpson, if you want to give your take on the position at Inverness, seeing as it's being raised.
Okay, hi, Mr. Reporter. I can't comment specifically on the history of the regulation of the Inverness site and why West Crum has been differentiated there as a fuel and not a waste as per Cowie. But there is a few differences between the two sites which may have informed that previously. The main one being the two different manufacturing processes, making two different products, and most importantly, the Inverness site only deals with virgin wood materials and not post-consumer wood or what is essentially waste wood coming into the Cowie site for the particle board process. So there is differences between the sites, but the other thing is we recognise there may be a consistency issue here in the regulation of indeed these two Norbord sites and the other wood-based panel site by another operator, and that is definitely something that will be addressed off the back of this this decision and everything else.
Thank you, Mr. Simpson. Any comeback from the Norbord side on that, the relationship with the Southampton, the Inverness facility?
Just one from me, just a brief comment. Andrew isn't quite right. I absolutely agree. It's a different manufacturing process and its feedstock is virgin wood, but the site procures biomass from a variety of sources. It's a different process altogether to Cowie, but it procures biomass from sources that generally may be regarded as waste from other sources. An example, for example, would be distillery drafts. So the waste from a particular industry is consumed on site as fuel.
Thank you. Well, let's go on to B then. So can the West Crum be used directly without any further processing other than normal industrial practice? So there seem to be two questions here. Does what is done to the West Crum amount to processing? And if it is processed, is this processing a normal industrial practice? Mr. Muir, I'll come to you first again on this one. I think we'll maybe just go through the bullet points that I've listed there individually, if that's the way that you've addressed it, and then we'll go to SEPA after each individual bullet point. So if you want to address the first bullet point there, please.
Yes, I think we've shortly said here that the focus is, in essence, not just on processing, but whether the substance or object can be used directly without further processing other than normal industrial practice. So, in a sense, processing itself is not the focus of that. Processing just means to undergo some form of operational process. The key is whether what happens is anything other than normal industrial practice. It's quite permitted to undergo processing. Question is the further processing anything other than normal industrial practice? And for the reasons that we go on to describe, both at this plant and more generally where one has a blend of fuel sources to be used in a heat energy plant, it's in fact vital that there is blending and therefore that normal industrial practice. So all I'm saying at 5.6 on your bullet point here is just to make the point that it's not really processing itself, it's whether the processing that it undergoes is anything other than normal industrial practice.
See, that's helpful. Ms. McGregor, would you agree with that the focus here should be on the normal industrial practice part of this condition?
Yes, sir. I think that's the way we have approached this too, is to focus on what is normal industrial practice rather than the processing itself, because as I understand it, there isn't much processing involved here. It's a blending. I think you asked later on about mechanical machinery, and my understanding is there's not involvement of mechanical in machinery. It is a blending process. Dealing with the first question here, does the combining of fuel sources amount to processing? And well, I guess if so, why are different fuel sources apparently allowed? Just to put some clarity around that, there is no restriction on mixing fuel sources under the permit. So it is possible to combine permitted fuel sources in order to improve the combustion efficiency of the fuel. Our focus has been on the normal industrial practice, and our position is that the mixing of the existing permitted fuel sources is different to the mixing of the West Crumb. And we say that the mixing of the existing fuel sources is to deal with physical properties of the fuel, the size, the shape, with the aim of maximising efficiencies. And I know we'll go on to deal with it later, so I don't want to preempt that now, but our position is that that's not the purpose of mixing the West Crumb.
Thank you. So I don't know, perhaps Mr. Lindors could help us on just making sure I fully understand what the processing involved here is. So the West Crumb is produced as part of the filtration process, but then if there is any further processing of it, then that would just amount to it being fed into the fuel stream, really, for the incineration plant.
Just to correct you, Mr. Hall, it's not an incineration plant. We don't have incinerators on site. It's a heat plant. The West Crumb, I believe if you look at Article 5 of the Waste Framework Directive, where it identifies product being generated from the process, which is not the primary aim. It's part of the byproduct definition. In my technical statement on the 22nd of January, I explained what we would class as normal industrial practices for a wood board production facility. Because the site handles somewhere in the region of 600,000 tonnes of wood a year, it is completely different from an oil refinery, a meat processing plant, or anything else. We have large pieces of equipment which we don't just use for getting the proper quality of the fuel. We also use shredders, ring flakers as part of processing our product to make board. So in our industry, what we would classify as normal industrial practices is loading shovels, shredders, size reduction equipment to get the proper size of our materials we need either for production or for producing a homogeneous combustion source of fuel. I don't know if that covers what you were looking for. Look at my technical statement from, as I said, the 22nd of January. There is some photographs in there which shows various biomass fuel sources on the site. If you look at the size and the shape, you see these have to go through what we would class normal industrial practices, which is to shred the material to homogeneous consistency. And then further go on in that technical statement to explain how the different sources, as previously mentioned, we also use reject fibre, which is a dry fuel source, and how we blend these in with the wet fuel sources. So basically, when it comes to normal industrial practices for a board production site, we're using normal industrial practices for generating a homogeneous fuel source.
But I take it the West Crum doesn't require shredding or those processes. Once you have your West Crum, the only process that is done to it is the blending.
Yeah.
Yeah, and that blending is effectively, is it different hoppers going into a conveyor belt that's feeding?
The proposal we have put forward is that we will put in a separate dosing system which is identical to the current one we use for the wet biomass. And then we can, to get the homogeneous fuel source using metering screws through our PLCs, etc., we can ensure we guarantee the appropriate consistency of the fuel.
PLC?
Programmable logic controllers, just basically the on-site control systems. So it'll be exactly the same purpose process that we have for bringing in the dry fuel to the existing wet fuel.
Can I just make an addition to that?
Yes, Mr. Roebuck.
Okay, obviously all those things require capital expenditure, so you will be talking about a silo, feed, metering screw, control system. We've already undertaken to SEPA that should the appeal be granted or should we be allowed to use it, we will spend that money. Clearly, we are not going to spend the capital until SEPA allows us to do this process. For the purposes of the trials that we ran and they're talked about later, we use some crude bucket scale mixing, if you like, but there would be a much more sophisticated control process. But as I said, we're not spending the capital on that until we have certainty that we'll be allowed to do it. That's your sense.
Okay. Thank you. We're still, I think, on the first bullet of item B. Any further comeback from anybody at SEPA? Yes, Mr. Simpson.
Reporter, yep. SEPA recognises that normal industrial practice is as Stuart has said there, size reduction and mixing and indeed drying in some cases with biomass. Having touched on this, the moisture content previously, we fully recognise that that is normal industrial practice to deal with that type of material for the purpose it's required. But the point that we want to make that is not normal industrial practice, and I indeed hope we come on to it in more detail in a moment, is the blending process for the West Crum in particular. And that, you know, I think it'd be more helpful if we refer to it as a dilution process, because it's, and then we have the information and we know the blending of that material has been necessary because of the hazardous properties within the West Crum and the need to dilute it down in order for it to be combusted and give satisfactory emission results. That is not normal industrial practice to have to deal with a material like that in order to achieve the emission results that you want, and that's, I hope, what we'll go on to in a moment.
Yes, I think we will go on to that. So we'll, I won't ask Norbord to comment on that point at the moment. Should we go on to the second bullet then, Mr. Muir? Second bullet under item B. Do you want to give us?
Yes, I think that 5.7. Does the West Crum require to be combined with other materials to make a usable fuel? I've made the point again that there's an obligation to reuse as many substances as possible. I've given you the references to the permit there. And as we know from table 1.3 and the technical statement, mixture of fuels is already occurring under the permit. And indeed for the appellant, as for other manufacturers who have heat energy plants or similar combustion plants, blending is essential when you have a combination of fuel sources. And I've noted there paragraphs 7 to 10 in Dr. Acton's affidavit of the 8th of January 2021. And that's document 12, I think, in the inventory of the various documents lodged by Norbord. But just by way of example, at paragraph 7, in that affidavit of the 8th of January, Dr. Acton points out that blending in of fuel sources is essential to control at least 4 particular issues. Firstly, the physical profile of the various fuel sources, so that the in-feed to the combustion grate of the HEP plant can properly deliver the blended fuel to the combustor. Secondly, the moisture content of the blended fuel to ensure efficient combustion, and that's something we've already discussed this morning. Thirdly, the calorific value of the blended fuel, again, to ensure efficient combustion, and the ashing percentage of the blended fuel, so that the combustion process within the HEP plant itself is proficient. So it's quite clear that all of these fuel sources, and they're listed side by side in table 1.3 at the moment, all of the existing ones. For all of those reasons, blending is required, and blending is a normal industrial practice. Now, when you blend Esmil cake, or if you blend Pal Fines, or if you blend those with other items that are listed under the present table 1.3, then you're clearly going to change the composition of the final product, the blended fuel, which you then use in the HEP plant. And that's true whether we're looking at the Esmil cake or the Pal Fines or the others. So there's nothing special or different about the particle board West crumb from any of those other ones. They all undergo and require to undergo blending for the purpose. And that blending, as Mr. Lindors has explained, is normal industrial practice. And we shouldn't forget that the condition B in Article 5.1 of the Waste Framework Directive is looking at normal industrial practice, not industrial purpose or industrial. The question is it undergoing a normal industrial practice? And in my submission, it's quite clear that it is undergoing a normal industrial practice. There is no further processing that is proposed for the West crumb that is any different from the industrial practice used for the existing fuel sources at table 1.3. That's wood residue, biomass, Esmil cake, Pal Fines, Aurora. So, and as we say at the end of the reply at 5.7, adding materials necessary for further use is recognized as normal industrial practice in the Commission's own guidance. And we are adding materials because to Esmil cake, there are added Pal Fines, wood residues, biomass, because the Esmil cake alone wouldn't be an appropriate fuel. So all of the permitted fuels at the present have materials added to them. And that will be true for the West crumb as well. And the fact that the combined fuel will end up having characteristics that differ slightly from the characteristics of each of the components of that combined fuel source is simply a product of the normal industrial practice of blending.
Okay, thank you. Was that all still relating to that second bullet?
Well, I'm looking at the next one in a sense.
I think there's quite a lot of overlap between these.
In a sense, perhaps it takes into account 5.8 as well, and I've mentioned there the different amounts of each fuel source available. There are about 650 tons of the particle board West crumb that would be used, that are available and would be used, but there are different amounts of the other fuel sources, and therefore another reason for the blending is simply to make sure that that you're using all of the fuel sources as efficiently as possible, but doing so in a way that gives you a homogeneous fuel. So the very fact that there are different fuel sources and that they have different characteristics obliges the use of blending. And I've mentioned calorific values, moisture content, and so forth. So yes, I think perhaps my 5.7 and 5.8 are perhaps dealt with together.
Yeah, I think we need to do our own blending between these different bullets. I think. Mr. Lindors, I just to follow on from that, I think we heard at the beginning that the point that was being made by SEPA that the West crumb was quite wet, and we heard the point being made that I suppose the argument from SEPA that what Norbord is seeking to do here is to dispose of the West crumb rather than really use it as a fuel. They're putting it through this process as a real means of disposal. So my question is, how much, if you look at the fuel mix that you have now, with the fines and the Esmil cake and so on, you're getting a certain amount of heat and energy from that. If you add in, if this appeal is allowed and you're able to add in the West crumb as well, will you be getting significantly more energy and heat than you are currently?
We would be generating additional heat. I'll touch on a point that James mentioned there as well when he mentioned Esmil cake. SEPA's point about moisture and the West crumb being roughly 50% moisture. The Esmil cake is a product from our effluent treatment plant. And that is the solids that comes out from the MDF chip wash. The Esmil cake will be roughly 50 to 60% moisture content as well. So because West crumb is 50%, other of our fuel streams have the same moisture content. The energy, and I did explain it in one of my technical notes, we have purchased biomass in the plant to supplement deficiencies on site. One of the purposes of the West crumb will hopefully be to reduce gas usage on our backup thermal oil heater. The primary source of heat energy for the thermal oil for the MDF press is the heat energy plant. If we are not generating sufficient energy or have sufficient biomass, we have a backup gas heater. So that impacts on cost of using fossil fuel, impact on greenhouse gas emissions, etc. So part of this process is to ensure we have sufficient quantities of biomass on site which we can control. We're not having to purchase any additional biomass to supplement the process, and we'll offset fossil fuel usage, which we sometimes have to rely on our backup gas thermal oil heater.
And have you quantified that, or could you describe?
In the first technical statement, which I think was on the 1st of October 2020, there is a breakdown in there of projected waste costs, but I've also looked at the use of the PB waste scrum as a fuel and broken down the gas costs, gas usage, and projected savings in CO2 emissions. So that's in my technical statement from the 1st of October 2020.
And you would say it was significant? Or well, I don't put words in your mouth, but would you say
looking at the gas savings,
a valuable fuel source for you?
Gas savings, we're looking at the energy, we're probably going to generate 3.25 million kilowatt hours. Potential cost savings on gas usage will be in the region of £32,000. So it is a significant amount. CO2 emission reduction are calculated roughly at 610 tonnes.
Okay, I'll come back to Ms. McGregor then for SEPA's position on, I think we're, well, on the matters that were raised by Mr. Muir. I'm not quite sure which bullet point we're on, but
neither am I. So
IGB.
If I overstep the boundaries, do shout. So dealing with, I think the first bullet point we looked at, does the waste crumb require to be combined with other materials in order to make it a usable fuel? I think we're agreed, yes. Blending is required in order to make it a fuel. If you then go on to the next bullet point, which I think we strayed into, the reasons for blending the waste crumb with other fuels, I think there is a difference as between SEPA and the appellant in relation to that. Our position is that blending is required for 3 factors. 1, to deal with the moisture content. 2, and it's a point that you picked upon, sir, is to avoid having to discard the crumb and the costs associated with that. But our third point is that we do say that the primary reason for blending is to deal with the hazardous properties of the waste crumb, which is where we and the appellant disagree. And we say that for a couple of reasons. First of all, as I understand it, although Andrew and Andrew may want to jump in after me, the trial was originally started off with a very different mixture of waste crumb to other fuel. We understand that the ratios were much lower. And the reason that we ended up with a ratio of 48:1 was because of the emissions levels at that lower blending quality. Secondly, we understand the primary reason for halting the trial in relation to the MDF crumb, WESP crumb, was because of the levels of lead emissions that were released during that particular trial. And so our understanding is that the blending, contrary to what the appellant says, the blending very much was needed in order to deal with the hazardous properties. And it's that blending to deal with the hazardous properties that we say is not normal industrial practice. Now, I know Mr. Lindor's raised a number of other issues, so I don't know if one of the other Andrews wants to jump in response to pick up anything else.
I could say a few things if Andrew Sullivan isn't there.
Mr. Sullivan's, I think, indicating you should go ahead, Mr. Simpson.
Okay. Just with that first point, does the West Scrum require to be combined with other materials in order to make a usable fuel? Then yes, absolutely, we've covered that. But absolutely, it is a very wet material, and in isolation on its own, it just won't burn. So it does have to be combined, albeit that might be argued as a normal industrial practice. With regard to the ESMIL cake reference, which appreciate that's an acronym, but it's a, a, a woody product which comes from the wastewater treatment process at the site. And yes, it's comparable to West Crum in the fact that it's a dewatered sludge and it's a woody material which will burn. The difference being massively that the lead content or the heavy metal content of ESMIL cake is nowhere near that of the West Crum. And as a consequence of that, the ESMIL cake is a permitted fuel, a biomass under the Industrial Emissions Directive as an exempt type of material that can be burnt without having to go through a full waste incineration process. And as a result of that, that is permitted at the site, and the site duly burn that as a part of their biomass blending. The West Crum doesn't fall into that category because of the heavy metal content. So even if it's wet like the ESMIL cake, it won't burn. It shouldn't be burnt the same way, and they don't have free rein to do that right now, which is of course why we're here. The other point I wanted to make was this fact about the ratios. Yeah, so we did go through the burning trial with Norbord. We know categorically that when West Crum is burnt, heavy metal emissions in the exhaust stacks which were monitored increase. And during that trial process, the initial blend ratio that was proposed was a 1 in 20 ratio. They didn't get, or we didn't see favourable results in the stack emissions with regard to heavy metal levels. And the whole reason why the blend ratio was pushed out further and diluted further was because of the heavy metal content. It was nothing to do with a combustion reason or poor combustion and carbon monoxide or nitrous oxide or other indicators of poor combustion process. It was all led on the heavy metal reasons, and that's why it was diluted further. So I appreciate combustion and blending of fuels and everything is a normal industrial requirement, but the purpose of the blending was for achieving favorable air emissions and in those results, and that's where we are.
So when you say that, that's based on your recollection of the discussions that were had at the time.
It's based on my recollections, but it's also covered in the trial plan. So as part of the trial plan with the agreed process and procedure and blending ratios and everything that was agreed up front, which included monitoring of emission levels where we felt we had a safe level to get to, and we would see it come to that and then maybe make a decision if we go further. But what was in there as well was a log or a diary of each of the days of the trial burn, and it's covered in there by Norbord staff indicating that the emission levels were not appropriate, and we're going to change the emission ratio to this as a result of that. And that was all, as I say, a result of the metal levels, the total metal levels.
Okay, thank you. I had a question, I suppose, coming on from Mr. Muir's point. I don't know who the best person. I'll start with you, Ms. McGregor, but you can pass this on to one of your colleagues if need be. There is blending done currently at Norbord of the various different fuel sources. Hence, it's a normal industrial process because they're doing it now. That seems to be one of the arguments being put by Norbord. How would you respond to that? I mean, there does seem to be this argument that the blending of West Crum is different because it's being done for a different purpose. Arguably, it's being done for this dilution purpose. Though I accept that Norbord don't agree with that. But if you look at the actual physical process itself of the blending, it doesn't seem, apparently, there's a great deal of difference between the blending of that would be done with the West Crum and the blending that is being done currently with the other materials.
So SEPA have covered this point in a number of the submissions that they've already made to you, sir, and the way they approach this question is thus. The document number 1 that SEPA have lodged is the European Commission's guidance on interpretation of the key provisions of the Directive on Waste. And that document provides guidance on what is meant by use directly without any further processing other than normal industrial practice. And SEPA have referred there to paragraph 1.2.4 of that document. And in that paragraph, it states that those treatment techniques that address typical waste-related characteristics of the production residue, such as its contamination with components which are hazardous or not useful, would prevent classification as non-waste. This is to ensure that such operations which might pose risk to the environment or human health are monitored under waste management law in accordance with the precautionary principle. On the other hand, a treatment which is normal industrial practice, e.g. modification of size or shape by mechanical treatment, does not prevent the residue from being regarded as a waste product. So applying that guidance, and I think the point is made in response to that issue for the appellant that this is just guidance, and I accept, of course, it is. But applying that to the West Crum, the further processing by blending, SEPA says, is to deal with the hazardous nature of the material. And it's that which prevents it from being normal industrial practice. Andrea, I don't know if there's anything you want to add to what I've said. Or Josephine, in fact.
But even if there weren't any hazardous substances within the West Crum, it would still require to be blended.
Yes, but there are.
Yes.
I don't think we can. If there weren't any hazardous properties and it was being blended, then that might be fine. That might be normal industrial practice. But it's the fact that you need to blend it, to dilute it, I think Mr. Simpson is saying, in order to deal with the hazardous properties. That is what takes it outside normal industrial process. And I don't think we can pretend that it doesn't have these properties. It does.
Yeah, I don't think you can dissociate the practice of blending from its intent. I think those things are very linked. So we understand that there is further processing required. That further processing is required both to address the physical properties of the material, i.e. the fact that it's wet and requires to be blended with drier material in order to combust. I think there's still a question about whether or not the energy required to dry the material outweighs the energy recovered from it later on in the process. But because it's also the processing is also required to address the contamination of the material. I think the intent and the purpose is material. I don't think it's just a question, and I think the guidance is quite clear on this, that it's not just a question of the practical actions that are taken. It could be taken for multiple reasons, but if the intent is to address its waste-related properties and its contamination in order to try and protect the environment as a special precaution, then that's unlikely to be normal industrial practice. It's certainly not normal industrial practice in the rest of the biomass energy industry to to be diluting contaminated fuels to achieve emission limits. That's not normal industrial practice across the broader biomass energy sector.
So it's not the physical act of blending in itself that's not normal industrial practice. It's the level of blending that's being done and the reason why it's being done.
I think so, sir, yes.
I'm also interested in that the point, coming back to the point which I think I was trying to get to Mr. Lindors earlier, about whether the energy, I think you said you weren't convinced that the energy required to dry the West Crumb outweighed the energy got from it. Do you have any evidence for that statement, or is that just?
Well, I mean, clearly there's an energy cost in including wet materials into the mix, and that's clear. They don't currently burn this material, so they don't need further wet material. They've already said this themselves. They don't need further wet materials in order to develop and deliver a fuel to the plant. So it's not as if there's a technical requirement for further wet material. And obviously there's an energy cost associated with it. So you're driving off the moisture prior to the combustion stage, and that comes with an energy cost. So I'd be interested in Mr. Lindors' assessment of whether or not that balances out and provides, any significant energy benefit, or whether it's whether it's pretty. It seemed to me to be pretty marginal at best.
I mean, I have I'll come to you in a moment, Mr. Roebuck. But just back to you, Mr. Simpson, I have Mr. Lindors saying that according to his calculations, there'd be a £32,000 a year saving on gas. So I think you're disputing that calculation.
Well, if Mr. Lindors said that they currently use maybe buy in additional biomass to keep the fuel running, I think that was a theoretical saving rather than an actual saving. Or did I get that wrong? That there would be a saving of £32,000 if you burnt this, if Norbord burnt this material.
Mr. Lindors?
That was a calculated saving on the reduction of gas usage. But Mr. Hall, I'd just like to make one point regarding the biomass. We don't dry the biomass. The combustion process has an integral drying process as prior to the combustion. We do not use any additional energy apart from what comes from the biomass. A heat energy plant does not have any backup gas heaters, and we do not go through a independent drying process to dry the fuel. As I tried to explain earlier on, the way the system is designed, it has an integral drying process as part of the combustion unit. So there is no additional drying equipment or drying costs to reduce the moisture content in our biomass waste streams.
Thank you. Mr. Roebuck.
Well, I was just going to point out in both of the comments, actually, we need additional biomass. So if we aren't using this material, we have to buy it in from somewhere else because we don't have enough, or use gas instead. And the second point is, of course, the calculation is theoretical because currently we're not allowed to burn it. So of course it's a theoretical calculation.
Thank you, Mr. Muir.
Yes, if I may, just on the question of the guidance, it's important to understand that the text that governs this situation is the text in Article 5.1. The question whether the substance can be used directly without further processing other than normal industrial practice. There is no reference in that condition to the content, chemical, hazardous or otherwise, of the substance. The sole question put there is normal industrial practice, and it's accepted that blending is the normal industrial practice. And if we look at the text at paragraph 1.2.4 in the guidance, the European Commission is suggesting that a treatment technique to address typical waste-related characteristics of the residue would prevent classification as non-waste. Now, it's not a treatment technique. The waste crumb is not being treated in order to change its composition. It is being blended because all fuel sources require to be blended for the reasons that Dr. Acton has given. S-milk cake, other biomass there, is blended not to treat it, but to make it into a homogeneous blend that provides efficient combustion in the heat energy plant. So I think the attempt to introduce some extraneous purpose or intention flies both against the wording of Article 5.1b, which is purely about normal industrial practice, and it doesn't fit with the specific mention about a treatment technique. In other words, you treat the item specifically to take something out of it, to treat it so that its composition is different. That's not what's going on in a fuel blend.
Thank you. Yes, I looked at paragraph 1.24 of the European Commission guidance, and I read the box. I don't know if people have that in front of them, but box 2, paragraph 1.24 is an example of wastes, including dusts from iron and steel production. So obviously it's a different type of industrial process. But in the second paragraph of that, it says another type of example is dust extracted from the steel production process when cleaning the air inside the plant. This is captured in filters via an extraction process. These filters can be cleaned and the metallic content returned to the economic cycle. And then it says, both this and another example are therefore wastes at the point of production. So I don't know how analogous that is to dust that is being captured and turned into waste crumb in our example. But I take that to be saying, it seems to be saying that the dust captured via an extraction process in this example in the guidance should be treated as waste. I may have read that wrongly. I don't know if people need a moment to look at that and think about it, but that's just one thing that struck me. Mr. Muir?
Well, these examples, of course, is that each one is very fact sensitive. We have to look at the facts that we have before us. But I think it's interesting that just above that box, normal industrial process, it says can include all steps a producer would take for a product, like the material being filtered, washed, dried, or adding materials necessary for further use. Each of the fuel sources has other fuel sources added to it because use in the HEP plant requires an appropriate mixture in terms of regular size, in terms of the overall moisture content of the combined or blended fuel source. And you have to understand that because of its calorific value, it is perfectly suitable for use as a fuel. And there are plenty of fuels that have hazardous hazardous contaminants in them. And coal itself is a fuel, but of course there are requirements about emissions because coal has, when burnt, will release elements into the air. That is true of all sorts of fuel sources, but that's a separate point from whether the normal industrial practice that is used for the fuel sources is no different from that for SNLK or PAL fines. So in terms of the box, that's simply saying what happens to this production residue. What we know in the application is that the residue here, the West crumb, is akin to the other fuel sources and has calorific value. And under condition 2.6, Norbord has an obligation to try to find a use for which it is so as to reduce the generation of waste. And that, of course, is part of the waste hierarchy.
Okay, thank you. Ms. McGregor, do you have any comments on that or more generally on how to interpret the example at box 2?
I think I saw Andrew Sullivan put up his hand, so if you want to take the lead, Andrew, and I'll come in behind.
Thank you, sir. So yes, no, I think I would interpret it in that way, and I don't think we're contending that blending could, in some circumstances, be in normal industrial practice, but when the intent is to do it as a special precaution for environmental protection purposes to address its contamination with hazardous substances, then I don't think that is industrial practice. So I think there is, again, that distinction between, we can't distinguish between the practical steps and its multiple purposes. And the purpose in this instance is to address its hazardous properties. Again, I accept that other fuels also contain hazardous properties, and coal was mentioned. Each of these fuels have a regulatory framework around them. Each of these fuels have their own emission limit values, abatement requirements, monitoring requirements, and contaminated hazardous waste also has its abatement requirements, its emission limit values. So it's all about understanding what these things are and applying the appropriate regulatory standards to those. In this case, applying Chapter 4 of the Waste Industrial Emissions Directive, which would require further abatement technology to remove the lead and remove the heavy metals from the emissions, not just dilute them further, and apply emission limit values and monitoring requirements on the plant would be appropriate. So just in the same way that similar requirements would be required for the combustion of coal at a power station. Making sure that we're applying the appropriate regulatory controls to the particular fuel based on its inherent properties. And that's how the framework's set up.
Can we not do that through a condition on the permit?
So I think the principle in IED is that we reduce emissions and that we prevent rather than just seek to dilute them. So applying the appropriate controls, which in this case we believe to be Chapter 4 of the Industrial Emissions Directive, would require potentially further abatement technology. So for example, other waste wood biomass co-incinerators in Scotland all use activated carbon injection to remove heavy metals and dioxins from the flue gas. So the abatement equipment that's in place at Norbord may not be consistent with that. It would set emission limit values for total heavy metals, and require periodic monitoring of that, and the other sort of requirements of Chapter 4 that go with it. The important thing is that the intention there is to apply BAT to remove as much heavy metal from the flue gas as possible, rather than just try and get to a blending ratio which may or may not be sufficient to mitigate impact.
Thank you. Mr. Roebuck.
Yes, just to go back again, we keep referring to this. It's not an incineration plant, it's a combustion plant. So let's please stop calling it incineration plant. It already has abatement equipment associated with it. So the HEP plant already has additional abatement equipment. It has its own WESP process, which is, if we go back to the BREF document, is regarded as BAT. And we already monitor all the emission parameters, and they are governed by permit conditions already. So ELV conditions are not something that's strange to us. To me, that seems an appropriate way to manage the process if we're concerned about emissions. Not simply say you can't do it.
So we're absolutely not saying you can't do it, but we would be in a position that the application of Chapter 4 would be the appropriate set of controls there. The comparison I was making to the other to co-incinerators in Scotland, which burn waste wood, is that they have tighter limits and additional abatement equipment to meet the limits of Chapter 4 for heavy metals. The WESP on the heat energy plant would be unlikely to be sufficient to meet the limits in Chapter 4. So further abatement would be required in order to meet those limits, and we think that those limits are the appropriate ones for this material.
Mr. Simpson, you had your hand up. I think you're on mute, Mr. Simpson.
Pardon me, Mr. Report. I think it's important to also stress that the point that Andrew made there, that a Chapter 4 IED process would have ELVs and abatement and everything in there to not simply meet ELV limits, but to reduce the emission of lead going into that massive emission of metals and lead, what we're concerned about here, going into the environment. The proposal to perhaps include a permit condition which would require dilution and require, perhaps, as Mr. Roebuck says, some sort of more stringent industrial mixing process, would still result in lead mass emissions increasing at the site. The air modelling and spot sampling might indicate that lead concentrations are lower, but the still mass emission is more lead will come out of the process as a result of this. And that flies in the face of the PPC general principles, the pollution prevention and control, where ultimately BAT is, best available technique, is to reduce and use less hazardous substances. We know this as a material standing alone on its own, it's a more hazardous substance, it's a special waste hazardous substance. And we also know that the requirement in BAT is to prevent or reduce to a minimum the overall impact of emissions on the environment. And we would be knowingly increasing them at the point I've said. So it doesn't meet that BAT standard either by moving in this way. It's a negative way. We're moving closer to the line of the ELVs and the limits of a wood-based panel process, not moving away from it as per BAT.
Okay, thank you. I'm slightly conscious of time, so perhaps we'll certainly give everyone an opportunity to come back on anything they still want to say under item 5B. But first of all, I'll come back to Mr. Muir. You probably didn't get to the end of your bullet points, Mr. Muir. If you could wrap up on item 5B, please.
Certainly. I think your point 5.9, sir, about in what practical ways blending a further process that wouldn't be required for the burning of other forms of biomass, I think perhaps that's already been covered in the contributions from Norbord, that the machinery is the same as that's necessary for any other fuel source of this kind, storage and metering, screw, and so forth. So that again is covered in the technical statement. At 5.10, you ask about the reasons why West Crum might be considered differently from other fuel sources, including palfines and S-mill cake. We say that the sources all comprise wood fibers and condensed volatile organic compounds, and in a sense, we've covered the next bullet that I make here already, and I've pointed you to our supplementary response on the 16th of July at paragraph 3. And we've pointed out that there is the second west that serves the heat energy plant. Now, I understand it's thought that further conditions might be necessary if the West Crum were added to the fuel source mix. But of course, there are emissions limit value tables set out in Appendix 6 to the permit, and of course it's perfectly possible for limits to be placed there if they don't already exist. And I think the limit at the moment for heavy metals is blank, for example, in Table 6.1. At 5.11, I addressed the question of whether West Crum can be defined as biomass, but in my submission, that's something of an irrelevance, because the appeal concerns the classification of West Crum as a byproduct, and there's been reference to the Industrial Emissions Directive, but that defines biomass by reference to specific products and wastes. It appears that SEPA's contention is that S-mill cake and palfines are wastes that fall within the Industrial Emission Directive definition of biomass. But of course, the question in the present appeal is not what they are, but rather whether West Crum is a byproduct and not a waste. And so the status of other materials are not, in my submission at least, directly relevant to the question that you have to answer, sir, which is West Crum a byproduct? Applying the four conditions at Article 5.1. So that was 5.11, and then 5.12. I suspect that, in a sense, we've covered much of this in the discussion already. Your question is, how is the phrase normal industrial practice to be interpreted? And I think I've made the point that what the legislation is directing us to is this a process that is normal industrial practice? And it is specifically silent in the legislation about the purpose of that practice or its consequence for particular substances. And of course, that may differ very widely from substance to substance. And if the intention had been to focus upon particular subcategories of normal industrial practice or the purpose behind the normal industrial practice, then it seems to me that would be on the face of the legislation, rather than requiring us to read that in, differing as it would be according to the content of the particular substance. That's simply not the way that the draftsman has done it. And I've made the point at the end of 5.12 that West Crum can't be used alone as a fuel source in any event. So there is bound to be blending, and the blending will, at least in large part, depend upon the relative amounts of each of the fuel sources that there is. And the intention is to use the West Crum that is there, the 1,300 tons, 650 tons once dry through the heat energy plant, along with much larger quantities of other fuels. In other words, the ratio is as much a consequence of the relative amounts of the different fuel sources that exist within the plant as it is of an intentional amount of metering that takes place to put together a particular fuel source. So in short, they all undergo blending. The amounts will differ because there are different amounts of each of these fuel sources. I think I'm right in saying that there's some 22,000 tons of other biomass that's there. So that is simply a consequence of the calorific value that's available from the other fuel sources used on site.
Thank you. On that point, perhaps Mr. Lindors, again, this is one for you. I think we've heard Mr. Simpson argue that the level of mix of West Crumb has been arrived at in order to reduce the amount of heavy metals in the emissions. Whereas I think the argument Mr. Muir was putting there was that no, the level of West Crumb in the mix is a function of the availability of the product of the different streams that are available to you. What's your understanding?
Yes, we do. From the other fuel sources, I believe they use roughly 22,000 tonnes a year on the heat energy plant. These can vary. If we have a good run on MDF, there may not be, well, there'll be a reduced reject fibre available. If the effluent plant isn't running as efficiently, there may be less Esmo cake. So it can vary on a day-to-day basis. The point Andrew or Mr. Simpson was making, I think it's just going away from our initial question, is this normal industrial practice of blending? And as I have explained, as Mr. Roebuck touched on, this was really rough and ready for the trials, where we were trying to blend the fuels using a 20-ton loading shovel. What we will be proposing to put in is a fully automated dosing system, just to ensure moisture contents, proper mix of the fuels is all there.
So this figure of 48 to 1 that's come about, how's that been arrived at?
When the trial plan was set up, we looked at the emission limit values for waste incineration. Now remember, it's a combustion plant, it's not an incineration plant we have. And we came to agreed limits with SEPA. If the heavy metals, one of them went above the level, we would cease the operation. Now, you also have to remember, we don't have any emission limit values currently on the site for heavy metals. So that was an agreement to ensure that SEPA were comfortable it was going to be a controlled trial. SEPA agreed the trial plan. As Mr. Roebuck, I see Steve's got his hand up there, that was rough and ready. The systems we will put in there will be normal industrial practices to ensure we have an appropriate blend of fuel.
Mr. Roebuck?
Yes, indeed. And the point that Mr. Simpson makes is the number we came to in terms of the dilution ratio at the end. It comes to, that's the ratio in which the fuel is produced. So that's where we ended up, is to what would be the normal status quo. I agree. At the start of the process, we were dosing at much higher rates, but that's the purpose of trial. It's to understand exactly where you are. We ended up with a blend ratio that got efficient combustion, was in the ratio of which the materials was normally produced, and caused no harm to the environment, because that's the other point that we had to be determined. We did that, obviously, we're not touching on it here, but a series of air dispersion modelling with our good friend Mr. Acton, who did all that modelling for us to demonstrate that at those emission limit values and at that level of combustion, there was no harm.
Thank you. I'll come back to Ms. McGregor then for SEPA, or you may wish to pass on to your colleagues, but your response to what you've heard there.
So I'll take it back to the bullet points and go through those, and then if anyone wants to jump in once I have finished. Starting then about further explanation of the reasons why the West crumb should be considered differently from the other fuel sources, including palfines and esmel cake. Mr. Muir is correct. In SEPA's assessment, both palfines and esmel cake are considered to be biomass, and therefore are different from the West crumb, which does not fall within the definition of biomass, and that's Article 3, subparagraph 31 of the Industrial Emissions Directive. In relation to why it's different from other fuels, I think we've already talked about the heavy metal content, the lead emissions, which makes it different, which takes it into the waste category. And Mr. Sullivan gave some explanation of the other fuels that the appellants had referred to, such as coal, and the regulations around those. So we do see West crumb to be different. It's not equivalent to palfines, it's not equivalent to esmel cake, and going on to your next bullet point, it is not a biomass. It does not fall within one of the definitions of Article 331. Then the last bullet point on 5B, how is the phrase normal industrial practice to be interpreted? I think we've already dealt with that at some detail. I think we in the appellant just view this are fundamentally very different views on how that phrase is to be interpreted. And we rely on the guidance that we've already mentioned in support of our interpretation. Mr. Muir suggests that if the legislative body had wanted something different, they could have specified that. I mean, I think we have to bear in mind that this was a directive that applies to a whole range of industries. It could apply in numerous different scenarios, and to start specifying what is or isn't normal industrial practice in any given scenario in any given industry would have been quite a feat. So I don't think we should read anything into the fact that the definition there is quite broad. Our position simply is that blending in order to deal with hazardous content is not normal industrial practice. And then Andrew, I don't know if you want to pick up on anything that either Mr. Lindors or Mr. Roebuck raised.
Hi, Mr. Porter. Yeah, I would just stress that difference in the types of materials that are burnt at the site, and we do understand that the wood-based panel industry, it's encouraged, it's backed to recover residues and wood fines and things like that, filter bag dusts and shredding dust and sanding and sawing dust. It's good practice to recover that, and it's a perfectly viable fuel to be combusted in the on-site combustion plant. The big difference here is that that material is size reduced. It is essentially wood that is small. It's the same material, it's just been shredded down, or it's been a sander result. The West crumb is through what you picked up on at the very start of this meeting, going through a different process. There's a wet process, a quenching process, where volatile organic compounds and filter dusts and other things are all extracted through that electrostatic process, and there's essentially a chemical change to it. So it's not the same type of material. It's essentially super concentrated in some respects, and that's why it's got higher lead levels, higher metal levels, to a factor of 10 above of these comparable ones that we're referring to in PAL fines and things. It has to be considered differently.
Any further points to make on item 5B then?
Just two very brief points, if I may, picking up on the reference to Article 3 of the Industrial Emissions Directive. The reference, and it's, I think, on page 15 of the consolidated IED, which is in the bundle at tab 3. But the section that I understand SEPA is referring to is Article 3, subparagraph 31, which deals with biomass, letter B, the following waste. So it's a definition that applies on the understanding or preconception that the products that SEPA is looking at are waste. Of course, the logically prior question that you, sir, have to deal with is this particular substance, West crumb, waste or byproduct? And that's a question that has not been put to any reporter or court in respect of Esmil, cake or PAL fines. So one can take nothing from the fact that SEPA regard those other substances as a form of waste that, for various reasons within the IED, is a waste that falls outside of Chapter 4 of the IED. We're at a logically prior point, asking ourselves, is this a byproduct in terms of Article 5 of the Waste Framework Directive? And perhaps a similar point just about the last point that was made for SEPA about chemical change and the necessity to deal with a substance in one way because of its chemical content. Of course, Article 3 of the Waste Framework Directive defines waste not by its composition, but by whether the user discards or intends or is required to discard. And that's a vital important point which I make at the beginning of the speaking note, that the fact that a substance may have certain qualities does not mean that it is automatically waste. And the point just made seems to me to fly in the face of that very fact about the definition of waste in Article 3 of the Waste Framework Directive. And that was for that reason that I included references in paragraph 1.8 of the speaking note to the definition of waste. Those were the only points I wanted to make, sir. Thank you.
Thank you. Any further points from anybody at this stage? Yes, Mr. Simpson.
I would just want to say that all of this, of course, is interpretation of the PPC rules and regulations, the Waste Framework Directive, the byproduct section, the best available techniques and everything. It's all an interpretation and how we take it and what arguments are for and against those. But what is known and what is a fact is that under the Industrial Emissions Directive, any biomass that is contaminated with heavy metals is a waste. And what we do know as a fact is that this West crumb is contaminated with heavy metals. So it's It's not an interpretation at that particular point. It's very clear.
Is it just worth pointing out that PAL fines are exactly the same, and yet they're declared as biomass?
Mr. Simpson, do you have a?
Mr. Report, I would say that my understanding is that's not the case from the information I have available to me, is that it had a metal content, but not to the same concentrations, and I believe as considered a special waste as historically has been for Westcrum.
And that
Now-
PAL fines are a wood dust, largely size reduced wood, whereas the Westcrum is a condensed gas cleaning residue from the off gases. So it's not just the same as, oh, it's wood but small, which is what PAL fines more or less are. This is something that is produced completely differently as a result of being the residue from a gas cleaning process. It's not just small wood, so it's not the same.
Can I just make one final point in response to Mr. Simpson saying that under the Industrial Emissions Directive, he said, I think any biomass contaminated with heavy metals is a waste. I don't understand that to be true, because the Industrial Emissions Directive provides in Article 3, subparagraph 37, that the word waste in the Industrial Emissions Directive has exactly the same meaning as it does in Article 3, paragraph 1 of the Waste Framework Directive. In other words, a substance that the owner intends or is required to discard. So there is no separate meaning of waste under the IED from that in the Waste Framework Directive. Thank you.
Thank you. If there's nothing else, then we'll break there, I think, for lunch. We're nearly at 1 o'clock. So should we come back? I suggest we come back at 5 minutes to 2, so 1:55. I'll see you then. Okay, thank you.
Thank you.
I'm back. I'm back. Are you next, Steve?
I'm back in the WebEx.
Can you hear me, Steve?
I can, but you've got that horrible. I can see two of you again. Why you appear as two, I don't know, but I think that's the root of the feedback. So.
Am I in back on that one?
Talk again.
Is it any better on that one?
Yeah, I think so.
Okay, right. I'm good.
Yeah, that sounds
Good to
better.
mute myself. Good to mute myself.
All right.
Good afternoon, everyone. That's 5 to 2. I'll just check that everybody is back with us again.
Bernard Action here.
Zero up.
Good. Right, I think that's everyone. Welcome back. I think we've making quite good progress, and we're through to item 5C on the agenda. Is the web crumb produced as an integral part of the production process? So again, if I could turn to Mr. Muir first for your views. Perhaps we just deal with the bullets together, Mr. Muir, on this one, and I'll hand over to you, please.
Thank you very much, sir. And again, this is, I guess, a point which SEPA responded on at paragraph 4.4 of their response on the 27th of November last year, accepting the analogy that the statement of appeal drew with the guidance at paragraph 1.2.5, which concerns gypsum, flue gas desulfurization, FGD gypsum, and essentially we have a material here, West Crumb, which is suitable for use as a fuel source, all other matters being equal, and which is a necessary part of the production process, and of course is something which is required under the permit. The activities and the directly associated activities being together the permitted activities covered by the permit at condition 1.2.2. And in my submission, it is certain that this results from the production process. Indeed, without this this directly associated activity, it wouldn't be possible to make the particle board under the permit. So I've, in essence, just revisited those points in the speaking note. That's 5.13, and it overlaps, no doubt, with 5.14, where the question was put: could the company's products realistically be made without producing the West Crumb? And I've given the references to the conditions in the permit, and also to the case of Brady against the Environmental Protection Agency at paragraph 44. So unless there's anything that you particularly wish to ask me on those points, I'm happy to rest them on what's said in the speaking note.
Thank you. I noted what you say. I've now had a chance to read this speaking note. So I noted what you said in your first bullet under 5C about the procedural unfairness if I was to determine this condition had not been met. I mean, I've no particular expectation of doing so, but if I think I would still be able to. And as to procedural fairness, I guess this hearing is the opportunity for you to make your case regarding that point. So I'm not quite sure if I'm debarred in any way from making an adverse finding on this point.
No, I think it was just the same issue arose, if you recall, this morning, and it was just making the point that if there are new matters which are put to the appellant today by you about this, which they haven't, in a sense, been aware of because they've occurred to you, they've not been points taken by SEPA, then if it were necessary, then a short written response could be provided if the matter couldn't be dealt with in the confines of today. But I would expect and hope that they can be if there's anything new that arises. It's no more than that.
Very well, thank you. Ms. McGregor.
Yes, thank you, sir. We take no issue with the points you just made there. It would, of course, entirely be open to you to find this condition isn't met should you choose to do so, but SEPA aren't taking any point in relation to this condition. They had originally made a distinction between the production process and the gas treatment process, which produces the WESP crumb, but having regard to the European Commission's guidance, SEPA document 1 and in particular paragraph 1.2.5 of that, SEPA accepts the analogy drawn by the appellant with reference to that paragraph, and so doesn't take the matter further. In relation to your second bullet point, I think we're in agreement with Mr. Muir. The company's products could not be produced realistically without producing WESP crumb. There is no real choice.
Thank you very much. Any further points from anybody else before we move on? Good, then we'll move on to 5D then. Is further use of the WESP crumb lawful? And Mr. Muir, I think again, perhaps if you just deal with all 3 bullet points, and I'll hand over to you.
Thank you very much. And in a sense, the starting point here is, I hope is clear from the original statement of appeal, is that the concern expressed in the notice of partial refusal, it seems to be that WESP crumb is special waste, and therefore its blending with other materials is contrary to special waste regulations at Article 18 of the Waste Framework Directive. Now, I'm sure so you readily understand that the SEPA position on this condition starts from the premise that the WESP crumb is waste, because it can only be special waste if it is waste. Whereas the purpose of the appeal is to determine whether or not it's a byproduct. So the only reason why SEPA say in their notice of partial refusal that condition D is not met is predicated on an entirely circular argument, because they've reached the conclusion that it's waste, whereas point 4, condition D, has to be answered before you can decide whether it's a byproduct or waste. And for that reason, we say at 5.15 in the note that the question isn't relevant to the matter for determination, because if WESP crumb is not waste but is a byproduct, the question doesn't arise. The question can't be made to arise by having in your mind a preconception that it's waste. Because hazardous waste, and I give the definition in the second point under 5.15, hazardous waste is defined as waste which displays one or more of the hazardous properties listed in Annex 3 to the Waste Framework Directive. And I've given the reference there to Article 3.2 and to the definition of hazardous waste in Regulation 2.1 of the PPC regulations. We're at a logically prior question. We have to ask ourselves first, is this waste or is it byproduct? So it makes no sense to have recourse to the definition of hazardous waste unless and until you're satisfied that having looked at A, B, C, and D, you're looking at waste and not byproduct. And I've referred to Dr. Acton's first affidavit, paragraphs 14 to 16. It's the affidavit from October last year. And I've given the reference to the notice of partial refusal, which is purely based on that preconception. And there are references to section 6 of our statement of appeal. So it's not, in other words, relevant to the determination of the appeal. One can no doubt ask, well, if you were discarding West Crum, what would it be? And one can look at that according to what's been done in the past. But as I think has been accepted, what we're looking at is what would the position be were the application to be granted. And as we've said repeatedly, the fact that something was waste in the past or required to be treated in a particular way in the past because of a lack of permission tells us nothing about whether it is or isn't waste or byproduct under a proposed permission. The second question that was posed is analysis of the actual levels of expected pollutants that would be emitted by the burning of the West Crum necessary for the consideration of this condition? In other words, would it be lawful? Now, we say no because, of course, the notice of partial refusal does not cite any actual or anticipated emission levels as the reason why SEPA contend that condition D would not be met. And that's an important point. The next point, of course, and it's clear from the analysis that Dr. Acton sets out in his affidavit of the 28th of September 2020, that's the date of the first affidavit, 28th of September 2020, that substituting the use of West Crum or adding it as a fuel source will not lead to overall adverse environmental or human health impacts and fulfills all protection requirements. And his description of the modelling and the results, which are all lodged with the document, the Statement of Appeal, are set out in paragraphs 10 through to 14 of the first affidavit. And he explains there not simply how the results were compiled, but also the precautionary way in which the tests were carried out. And as he puts it, a bad worst case scenario, which he describes at paragraph 14 of that affidavit, included known overestimations because the mean of the highest two recorded lead emission mass release rates from each of the implicated processes were modelled. So they've taken the highest mass release rates. Secondly, it was assumed that all of the processes operate for 100% of the time, whereas in reality, the percentage of on time is more about 80%. And thirdly, that the dispersion modelling procedures added the predicted emission of the pollutant in question to the known existing background concentrations of the pollutant, which itself include the plant at Cowie. And therefore, there's a double counting of the output at the plant. And as Dr. Acton concludes in his paragraph 14, even under that bad worst case scenario, the impact assessment showed that emissions of lead would not result in the exceedance of the long-term national air quality objectives in ambient air around the Cowley installation, or at any sensitive receptors in the vicinity of the site. In fact, this bad oblique worst case scenario assessment calculated the maximum possible impact to be some 9 times lower than the current long-term UK national air quality objectives. And therefore follows that the actual impact of the real life scenario will be significantly lower than that 9 times lower amount itself. And again, just for your own reference, the exhibits to the affidavit are, I think, in tab 7 of the documents which Norbord has lodged. And exhibit 5 is the Ricardo and Alderley Consulting Group report of July 2019. And Dr. Acton's expansion report is just behind that within exhibit 5 to the affidavit that I've been reading from. And it's in that expansion report of August 2019, following the various trials, tests, and Ricardo report, that Dr. Acton summarizes the impact assessment and sets out the details of those 3 overestimations, which I've just described. So those are the references that I've included under 5.16, and those are the results of the trials. As far as the lawfulness goes, it's interesting that the document which SEPA refer to in their final comments and response is, I think, a World Health Organization fact sheet, which I don't think was lodged by SEPA, but in any event, it's not a sheet that lays down limits for the United Kingdom, and the levels of the emissions levels for lead, which was the heavy metal of particular interest during the trials. I think we've seen already from Appendix 6 to the permit that at least to date, SEPA has put no emission level value, emission limit value for lead or the other heavy metals. And as I say, what the trials showed is that in respect of the limits that we have in the United Kingdom, as Dr. Acton puts it, paragraph 14, 9 times lower than the current long-term UK national air quality objectives, and that objective is Exhibit 6 to the first affidavit. So before I go on to the last bullet point, just to summarize there, the reason in the notice of partial refusal is not, in fact, a concern with the emissions of lead or any other matters in the trials, but rather the preconception that what we're looking at here is waste. And secondly, that when it comes to what the emissions say and the reports that were made by Ricardo and by Dr. Acton, it's clear, firstly, that there are several overestimations, and finally, that the maximum possible impact is some 9 times lower than the current long-term UK national air quality objective for lead. And on that basis, nothing has been produced by SEPA in response to this appeal to suggest that the use of the West Crum as one of the fuel sources would be unlawful. The last question which you posed, so was this: does the blending of the West Crumb with other fuels amount to the taking of special precautions in order to eliminate adverse environmental or health impacts? That of course is not a point raised in condition D itself of the Waste Framework Directive, which of course is focused upon the substance fulfilling relevant product, environmental and health protection requirements for the specific use, and will not lead to overall adverse environmental or human health impacts. But if one wanted to ask that question, is this taking special precautions? Again, it goes back to the discussion so that we had before lunch, that as with the other fuel sources already permitted, the blending is not a special precaution concerned to eliminate any environmental impacts, but rather a normal industrial practice. And just on that point, it's perhaps worth emphasizing, if it didn't come over before lunch, that the ratio at which the West Crumb will be used with other fuel sources is simply the ratio at which all of these sources are produced. So they are all produced. They will all be used as fuel sources. The trials began with, if I can put it, worst case ideas, because I understand that Norbord had to accumulate for several weeks the West Crumb and indeed get permission to stockpile it for the purpose of worst case scenario trial, in which the West Crumb had an overly large percentage of the input to the trial. But what is proposed and what was finalized at the end of the trials was simply that the fuel sources would all be used up in the ratios in which they are produced. So in my submission, that again points away from these blending operations being in any sense special precautions. Rather, they are normal industrial practice as used here and indeed at other plants. The case of Arco Chemie, which is cited in SEPA's latest comments, concerned a very different question, namely whether the particular substances were or were not waste, whereas of course the present appeal is about whether the West Crumb meets the conditions set out for a byproduct under the 2008 Waste Framework Directive. And then we mention in particular SEPA's citation of Article 13 of the Waste Framework Directive. This is the article which is headed Protection of Human Health and the Environment, and it's been quoted by SEPA both in its response in November last year, paragraph 4.5.8, and again in its comments at the end of May. Now, that article obliges member states to take necessary measures to ensure that waste management is carried out without endangering the environment or human health. But again, so that article, by definition, applies only to the collection, transport, recovery, and disposal of waste. And there's a definition in Article 3, subparagraph 9 of the Waste Framework Directive for the term waste management, which is, of course, the term used in Article 13. So it has to be waste first. But if, as Norbord contends, the West Crumb is a byproduct and not waste, Article 13 simply does not apply. It's what lawyers call a bootstrap argument, an attempt to construct an argument out of nothing, if you like. So Article 13 simply cannot apply unless you have already answered the logically prior question of whether this is or is not a byproduct. And therefore, essentially the key points that are made by SEPA under this head don't answer the question, because by regarding it as special waste that cannot be blended, they're taking for granted that it's not a byproduct. By seeking to apply Article 13, again, they're taking for granted that it's waste and not a byproduct. And when it comes to the emissions, they do not, in their notice of partial refusal, suggest that there is anything wrong with the emissions levels that were produced in the trials. And Dr. Acton's expansion report and his affidavit set out the details of those tests and the outcomes. Now, the second affidavit of Dr. Acton on the 8th of January 2021 also deals in some detail with the question of the results of the tests, and I won't read all of that out, but plainly the reporter will wish to look at all of that. And again, just on the question of the blending ratio, it's paragraph 10 in that second affidavit of the 8th of January, paragraph 10, where Dr. Acton himself explains that the ratio is as much an outcome of the amount of waste scrum material available to burn and the relative amounts of that and the other materials. So, so that's the key response to what the notice of partial refusal says, and to what appears, as I say, to be SEPA's attempt to answer condition D by first answering the question for themselves: is this waste? And as I say, for the reasons I've given, that is simply not. That is simply a misguided way to approach whether these four conditions are fulfilled. I don't know if anybody else from Norbord wishes to add anything to that at this point, or whether you, sir, wish to pose any particular questions of us.
Yes, I in some ways I found this condition the hardest to get my head around, probably because I'm not a lawyer. But looking at the EC guidance, which it sets out to tell us what is meant by further use is lawful. It says that the further use of the material must be lawful. So the burning of the waste scrum must be lawful, i.e. the substance or object fulfills all relevant product environmental health protection requirements at EU and member states level. So I might take from that the main concern here is whether the emissions out of the chimney would meet UK emission restrictions. And then it goes on to say, and will not lead overall to adverse environmental or human health impacts. And I was a bit confused by that, because not all adverse environmental and human health impacts are unlawful. Certainly in a planning context, we're balancing impacts all the time, and approving developments that have some adverse environmental impacts because they might have greater benefits in other ways. So I suppose those are my two questions: whether in terms of meeting the burning of the waste scrum, meeting the relevant requirements, is really about, do the emissions out the chimney meet the relevant UK requirements? And secondly, that slight confusion in my mind about not leading to any overall adverse environmental or human health impacts. Can you help me with either of those, Mr. Muir?
Just looking first at the second one and the overall environmental impacts, of course, one of the other matters which Norbord has considered is the reduction in the use of gas at the site and the environmental impacts of saving fossil fuels. equally saving of the impacts on the environment, both locally at Cowie, but also through the United Kingdom in moving the substance in the bulk containers by lorry to England. So in a sense, there's a wider balance to be considered there. But in terms of meeting of the UK regulations, the affidavit specifically focuses on the values that exist nationally for air quality, because those are the ones which, in the absence of emission limit values in the permit itself at the moment, those are the national air quality limits that plainly apply at and around the plant. And it's for that reason, I think, that the expansion report focuses upon that, and indeed Dr. Acton's affidavit as well. But it may be that he or the representative of the Norbord want to add anything to what I've just said on those air quality limits.
Mr. Acton, I had one question perhaps relevant for you here before I give Ms. McGregor a chance to come in on this. And it's just that this point about the long-term air quality objectives, and are there also limits for, is this about an average over a length of time as compared to individual spikes? I suppose is my question.
Yeah, air quality standards are sometimes expressed as short-term problems and or long-term. The standards for lead look at the annual effect. So we take the mean results over the tests and then calculate how many hours a year that is likely to be to operate like that, and that's the mass of lead that you calculate its impact on the environment.
And that's because the potential health impact of lead is about an overall build-up over a long period of time, rather than the sudden exposure to a big spike.
That's where the air quality standards are, yes. In the workplace, you've got short-term and long-term, but for the environment, it's an annual effect.
Thank you. Ms. McGregor, do you want to respond to this? Well, both to what Mr. Muir said and generally on this point, and also my questions. I think you're on mute, or at least I can't hear you. No. You're not on mute, but I can't hear you.
No work.
That's maybe better.
Oh.
Yes, I can hear you now. Oh.
I'm going to try again. Can you hear
No,
me?
that's fine. Yes, I can hear you now. Good.
My microphone was having a moment. It must be that time in the afternoon. So, yes, I think the key point in looking at D is to look at the full wording of that condition. It's not just is further use of the West Crum lawful, but then it then goes on, as you have pointed out, sir, to say the substance or object fulfills all relevant product, environmental and health protection requirements for the specific use and will not lead to overall adverse environmental or human health requirements. And it's certainly SEPA's position that it will, burning of the West Crum in the way that is planned, suggested, in terms of this variation would lead to overall adverse environmental and human health issues. And I noted Mr. Muir saying that emissions don't seem to have been a concern. I mean, SEPA would fundamentally dispute this. Right from the very outset, emissions were the concern when the trial was being set up. It was being set up with emissions in mind and controlling levels of lead. So I don't think it is fair to say that emissions weren't a concern. That's absolutely not correct. Dealing with the bullet points that you have raised, the questions you have raised, if the West Crumb were to be considered waste, then would it be special waste? Now, you've underlined if they are, and that's an important underline, but yes, our position is if the West Crumb were to be considered waste, then it would be special waste. It is hazardous due to its heavy metal content. And dealing with your second bullet point, is analysis of the actual levels of expected pollutants that would be emitted from the burning of the West Crumb necessary for the consideration of this condition? Contrary to the appellant's position, our position for that is yes. We've said in our responses to this appeal, at least on one occasion, that this site is the largest mass emitter of lead in Scotland. And burning of the West Crumb in the manner proposed by this variation will always lead to an increase in mass lead emissions. And that's just echoing something Mr. Simpson said this morning. And in the trial, lead levels increased every time the West Crumb was burnt. And I don't think Dr. Acton's work disagrees with that. There is an increase in the amount of emissions. Their position is simply that that increase is not of a level to be concerned about, I guess. Then we look about to the point about the ratio and how that was arrived at. We've said this morning, and I think we will say again, our understanding was that the ratio was arrived at specifically to deal with emission levels. Right at the very outset of the trial, metal concentrations and emissions were observed to increase. The very early ratios were, I think we talked this morning about 20 to 1, were considered not to be appropriate because of the levels of emissions that created. And we did arrive, as I understand it, and I think Mr. Simpson confirmed his understanding of the trial results and also those he spoke to, the ratio of 48 to 1 was arrived at in order to ensure that emissions concentrations were kept at a lower level. But dealing with that 48 to 1 ratio, as I understand it, the material is variable, and so that ratio may not be appropriate even if it's the correct ratio. But given everything the appellant has said today about 48 to 1 and where that's arrived, I'm not even sure that we're at a stage where 48 to 1 is the correct ratio. I'm not clear, and maybe the appellant, when they have an opportunity, can come back on that, what exactly we are saying is the correct ratio in order to ensure emission levels are kept in an appropriate level. Their position on that seems to vary. And then dealing with human health and environmental considerations, Mr. Muir is right. In SEPA's response of the 31st of May, we have referenced the WHO's fact sheet on the World Health Organization, fact sheet on lead poisoning and health. And that provides that lead is a cumulative toxicant that affects multiple body systems and is particularly harmful to young children. And importantly, that there is no level of exposure to lead that is known to be without harmful effects. It also goes on to say that one of the main routes to exposure to lead is from the inhalation of lead particulates generated by burning materials. And then it goes on to say that lead exposure is preventable. So I think, taken in the round, what we're looking at here is a mass emitter of lead. And what the appellant is proposing to do is to increase the level of lead yet even further. And what we in SEPA are saying is that there is a concern about that. There is a concern about allowing yet more lead from this facility to be released into the environment. And I think it's important also that we make clear that it's not a choice, as SEPA sees it, between granting this application or sending all the West Crumb down to Southampton or another one of the high incinerators for burning. It's not a choice between those two. There is a third way. We say that the appropriate way for Norbord to do what they are proposing is to apply under Chapter 4 of the Industrial Emissions Directive. And when considering that application, SEPA can then consider what appropriate controls are needed in order to deal with the lead emissions. And we heard Mr. Sylvan and probably Mr. Simpson this morning talking about how that would probably require some sort of additional abatement technology in order to deal with that lead, to make sure that there wasn't an increase in lead and to ensure that we do have that consistent and ongoing and continual monitoring. Then we move on to your third bullet point, and that mentions the blending of West Crumb with other fuels and whether that amounts to special precautions. And I agree with Mr. Muir. This goes back to our discussions earlier this morning. We just come at this from fundamentally two very different perspectives. SEPA's position is that the blending of West Crumb with biomasses in order that the lead content isn't such as to lead to overall adverse environmental or human health impacts means that it is a special precaution that is being taken. And we have referenced the Arco Chimie case in our responses to support the suggestion that if you take special precautions before you use the material in question, then that again tends to suggest that it is a waste. It's not a byproduct. We're not meeting this test. We just come at this from two fundamentally different perspectives. Then I don't know if Andrew, there were questions raised about the current permit levels within, or the current emission levels within the permits for heavy metals. I don't know if one of you want to pick up on that and anything else you feel we ought to cover in response to the issues raised.
Okay, thank you, Fiona. Mr. Reporter, yeah, there was a reference made to there being no concurrent emission limit value preset for metals within the permit, and that is correct. The company are required to monitor metals, but I believe that's unique to the Cowie site, and it's not an industry-wide site, an industry-wide requirement for the wood-based panels production. And the reason that is purely because metals aren't anticipated to be in the emissions, because the company, the industry are set up to filter out metals. To any waste woods or post-consumer woods that come into the process to be used as a raw material are supposed to not contain metals because of the gatehouse protocol and the trouble they're supposed to go to prevent this and to ultimately prevent metals coming out the stack. But we do know, and that's also reflected in the BREF document for the industry and BAT, best available techniques for the industry. There is no listed abatement systems within the standard wood-based panel industry which tackle metals, unlike what we do know are within the IED waste incineration processes, where they have specific abatement that we've alluded to already. So it's the fact that we do know burning West Scrum does increase metals levels in the emissions, and I do understand that the predicted modelling doesn't necessarily state that the annual air quality standard, the annual mean exposure, would be of concern, but importantly, that mass emission level will only increase with metals levels with the burning of this material. Something else I wish to say. Well, we've already touched on it, that the company is, this site is the highest ranked site under what we call the Scottish Pollutant Release Inventory, SPRI returns, which is a system for officially reporting annual releases of specified pollutants. And unfortunately, Cowie Norbord site is the highest emitter of lead amongst a bunch of other materials because of the scale of the process. So when we think of it in that sense of the World Health Organization's statements around lead and it being a cumulative toxin and everything else, it undermines those measures that SEPA, our general principles, and best available technique are all around, which is moving away and reducing emissions, not increasing emissions to the limits. That's everything.
Can I just add one minor correction there to what Andrew said? All particle board manufacturing sites in the UK measure metal release concentrations and masses quarterly throughout. Sorry, one site every 6 months, the other sites it's quarterly. Thank you.
Thank you. Thank you, Mr. Simpson. So do I take it? I'll come to you, Mr. Roebuck, in a minute. I'll just ask a question to Mr. Simpson. What's come across strongly to me is that SEPA is resistant to any increase in lead pollution from this or presumably any site. Is that correct?
Well, in a word, yes, but for what we think are, of course, the legal reasons, the right reasons with regard to there being regulatory controls and regimes in place where these emissions can be mitigated against properly, ultimately what we're calling this waste incineration Article 4 of the IED.
Yes, as Andrew said, so the regulatory framework that's designed for the wood-based panel industry does not anticipate these kind of releases, so it doesn't set emission limit values for heavy metals. Which is sort of one of the issues here at stake, and so our view there is quite clear that we think that, well, this isn't equivalent to biomass, normal biomass. It's not equivalent to the palfines or the S-mill cake. That it couldn't be used on its own. Even if you dried it, it wouldn't be suitable to use on its own as a fuel. That it does require to be diluted to manage its hazardous properties, and we consider that to be a special precaution that's not industrial practice. And it so happens that the ratio that they've settled on is the production ratio, but we've seen that at higher ratios there are serious concerns, and we've seen that even from Norbord themselves, who abandoned the trials of the other West Scrum, that the West Scrum in general can lead to these risks, and that it will lead to an overall mass emission, and that we consider that this is discarding the West Scrum into the fuel mix via dilution, and so So we consider this to be waste, and that the most appropriate regulatory framework, which does include heavy metal limits of 0.3 milligrams per meter cubed, is via Chapter 4. And that would ultimately require some additional upgrade to the abatement plant, which would remove heavy metals from the flue gas rather than just disperse them. So I think it's about, these definitions are really important because they allow us to apply the correct regulatory framework for the industries in question. Like Andy said, the wood-based panel industry framework doesn't anticipate this kind of fuel, and whereas the waste incineration one does, and applies the appropriate controls to that.
So in that context, how am I to consider the UK air quality standards that Mr. Acton's work implies can be met? What status do these UK-wide levels have?
So they have status in law, and it would be grounds for us to refuse a permit application if the process contribution was likely to breach these limits. But it's only one consideration. The application of BAT and the emission limits set out in Chapter 4 of the IED, for example, would have to be met regardless. It's not a case that if I was to build a municipal waste incinerator, for example, that I would be allowed to emit as much heavy metal as I possibly could, provided it was below the ambient air quality threshold. I have to meet that. I have to reduce it as much as is possible, and then we're going to decide whether or not it breaches the air quality limits. It's not something we're allowed to just work our way up to. We have to have demonstrated firmly that we've taken all appropriate measures to reduce those emissions before we do those calculations. And I think in this case, the application of Chapter 4 is the best way of doing that.
Okay, I think we're possibly coming on to the question of that. Mr. Roebuck, you had your hand up earlier.
Yes, I did. I had a couple of points. The first one was the question around are other sites in the UK in this industry measuring metal content in the emissions? Yes, they all are, but that point has already been covered. The second one is I think it's a little disingenuous to suggest Chapter 4 and suggest there is a third way. The area would have to be permitted for incineration for that to happen, and it is not. So you simply can't build an incinerator wherever you like. The area has to be zoned for incineration. It is not.
If I can just add to that point, so because I was going to make a similar point by reference to Chapter 4, which has been mentioned on several occasions. Chapter 4 of the Industrial Emissions Directive, which is at page 43 of the consolidated version, that I think tab 3 in the documents from Norbord, is headed Special Provision for Waste Incineration Plants and Waste Co-incineration Plants. So, as Mr. Roebuck says, these are provisions that are there for incineration plants. The heat energy plant at Cowie is not an incineration plant. It is a combustion plant. And there's a fundamental distinction, as I'm sure we're all aware, between combustion, and which produces energy, and incineration, which destroys matters. Now, the fact is, as Mr. Roebuck says, there are other regulatory requirements before one could have an incineration plant. But the idea that Chapter 4 would apply is, it seems to me, negated simply by Article 42, subpara 1 of the Industrial Emissions Directive. This chapter shall apply to waste incineration plants and waste co-incineration plants. That, as I say, is not what the heat energy plant at Cowie is. So that was one point.
On that point, is SEPA's argument not that the Cowie facility should include an incineration plant?
Yes, that's right. We may agree that it's not currently regulated as an incineration plant, but the addition of this material would make it such, because we consider this to be a waste on the basis that it fails against the tests in Article 5. Yes.
Well, again,
and just the point about zoning, there are no proactively zoned areas for waste incineration plant in Scotland. That's not how the planning system works for incineration. It would be just a question of applying for planning consent as every other. There's no proactively zoned sites for incineration.
Yes, Mr. Muir.
Well, I think so. The point about the Industrial Emissions Directive, and the reason I mentioned it, is that it doesn't appear to me that that argument is really an argument that condition 4 is not met. Condition 4 is looking at lawfulness. Indeed, condition D at Article 5(1) poses the question, is further use lawful? And it then goes on to explain what lawful is. But the key question is it lawful? And as far as I've been able to understand, the notice of partial refusal, which takes a particular and specific point that I hope I've fully responded to. In other words, you can't approach this condition on the basis it's definitely waste. You have to ask yourself, is future use lawful of this substance? Forget whether it's waste or what it is. The question is can this substance be further used lawfully? And as I say, preconceptions about whether it's waste or not don't assist. But also because I think it was said that the UK air quality standard does have a status in law, and it was said that SEPA would be within their power to refuse if an operation were likely to breach the UK air quality standard. That, as far as I read SEPA's response, is the only piece of law to which they refer as an express limit or value that is relevant to the emissions that were tested. The other references to VAT and so forth don't set up a legal test, and nor indeed does the case of Arco Chemie or Chemie. And then the final point, just to respond to the question about the ratios, was to make the point that what Norbord are proposing and would install by way of equipment would be a measuring screw to make sure that the ratio based upon the amounts generated of the various fuel sources could not be exceeded. So the suggestion that there were risks or concerns seemed to come down to the fact that Norbord wouldn't operate it according to the agreed measuring screw that they're going to purchase, which there is no basis to suggest that, as far as I'm aware. So I think those were the points that I wanted to make in response.
Thank you. Any further points on this item D? Good, then we'll come on to, let's say it's not numbered in my agenda, but item 6, I suppose, other matters. I think we'll perhaps deal with these bullets individually. And starting off with this question about best available techniques. Mr. Muir, again, do you want to kick us off on this one, please?
Thank you. The BAT best available techniques, I think I think both sides of the appeal understand that this may include combustion on site, and plainly that's built into the conditions that the permit has, encouraging the use of as many of the residues, byproducts, and so forth as possible. The back conclusions that are mentioned by SEPA in their original response include encouraging the use of waste, but also residues, including internally collected wood residues, wood fines and dust collected in dust abatement systems and so forth. So combustion on site is plainly, I think, the best available techniques. And the desirability of avoiding the waste generation and the preference given to finding a use for substances that you don't wish to discard, and we've made it clear that Norbord doesn't wish to dispose of this by discarding to incineration, precisely because of its calorific value, the saving in money and the saving in carbon emissions. So all of those principles, it seems to me, suggest that use as a fuel in the on-site combustion plant may well represent best available techniques, and the fact that it's a substance used elsewhere, for example at Inverness, which includes a fuel blend, including, as I think Mr. Roebuck mentioned, distillery draft, demonstrates again that that use of these substances and similar fuel sources are best available techniques.
Ms. McGregor.
Others should feel free to. Oh, Josephine, do you want to take this?
Do you want me just? Yeah, I can come in here. So I think a few points to make. First of all, really, again, due to we've covered various points and what's been said today about the distinction between the materials. So due to this, the waste coming from this abatement system, this is a very different type of material to what is being described in the back conclusions here. And so SEPA's position very much is that the combustion of this waste crumb would not be BAT. If we look at the specific things mentioned actually in BAT 12, it obviously covers things that quite rightly the appellant does do, and which we would obviously encourage as being BAT. Under BAT 12, the first one being reusing internally collected wood residues. So that clearly is carried out at the installation. And under point B, again, using internally collected wood residues, and it gives examples of wood fines and dust collected in a dust abatement system, as well as wood sludge from wastewater filtration as fuel. So it really gives specific examples of what it's referring to as being BAT, where these would then be used as fuel. And that is, it rightly covers the use of the palafines and the esmil cake as fuel in the on-site combustion plant, but this would not cover the West Crumb, which is not an internally collected wood residue. It's not collected in a dust abatement system. So there's no reference in BAT 12 here to what we're dealing with today, and it's very much SEPA's position that this would not be BAT, due again to the heavy metal content of the West Crumb. And I think just perhaps coming back also, I should have come in just on the last point when we were discussing just about this point about looking at the lawfulness and looking at a specific ELV. So again, what Andy Simpson and Sullivan had both been making earlier, this point about the overall general principles of PPC regulation and the requirement on us when we look at any permit, granting any permit or any variation such as this, is really always to be taking all appropriate preventative measures to reduce pollution and applying that. And so it's not about, that's not about meeting an ELV. And quite often you've got your ranges of ELVs. It's about doing everything you possibly can through every stage of the process to reduce those emissions. So it's not about, again, with the references to the air quality standards, about moving to this upper limit. The main principle under PPC regulation and BAT is really always doing everything we can to reduce emissions. So I don't know if
Can I make one correction there, please? The WESP is a major dust collector on the site. It's designed to be 97% efficient for dust, 50% for formaldehyde, 70% for VOCs. So particulate, its prime purpose is to remove the dust from the dryers, 97% efficient.
Yes, I think I had sort of thought it perhaps did count as being a dust collector, but
so that's part of its job. But I think that just demonstrates what Dr. Acton said. Just demonstrates that when you look back at BAT 12 there about internally collected wood residues, the WESP is not a wood residue. It's partially a wood residue, but it's not a wood residue in the way that BAT 12 is getting at, which specifically talks about dust abatement systems and wastewater filtration. Basically, it describes the PAL fines and the ESMO cake. It does not describe the WESP crumb.
Can you explain a bit further why it isn't a wood residue? Because it does come from
I'm
wood.
saying it's partially a wood residue, but it's also, as Dr. Acton said, the condensed formaldehyde from the glues that are used in the process. It's not just collected. It's not just wood, but small, like the PAL fines and the ESMO cake. It's an entirely different material made from a flue gas abatement system, which is partially wood residue.
I understand. Thank you. Any further comments on this first bullet about BAT? Then can we come on to the second bullet then? And I think this is where I'm getting.
Excuse me, sir. I think Mr. Lindors has his hand up.
Sorry. Yes, Mr. Lindors.
Thanks, Mr. Hall. Just wanted to correct comments for Andrew there. There is no resin addition in the material that's processed through the dryer prior to entry to the WESP. So there is no other additives put into the raw material streams. Prior, as Dr. Acton pointed out there, the main purpose of that is to remove the fine wood materials from the drying process. But just to correct the point, there is no additives put in prior to that waste gas going to the WESP.
There is, sorry, Mr. Reporter, if I may. There is, however, extracted emissions from the press and the pre-press and main press on the PB1 line, which are, of course, affected by resins, formaldehyde emissions and everything else. And they are also cumulatively vented to the WESP and a part of that abatement system. And the point that Andrew is trying to make, that is essentially the WESP crumb is a chemically different material from the filter dusts and the bag filters and everything else.
You know yourself that the press extraction is taking the formaldehyde fumes from the press process. There's not going to be lead there. And the volume throughput from the press extraction compared to the dryer extraction is, I'll probably be guessing, about a tenth.
But I believe we still are dealing with volatile organic compounds coming from the press going to the west, which was the point that was made. The other thing I was wondering about, and Stuart, while we're having this dialogue, there's mention previously of formaldehyde scavengers. Are these? Could you clarify this point? Because this is a chemical additive which is designed to help condense formaldehyde in the emissions in the west to extract the formaldehyde, ultimately resulting in those compounds being in the west crumb. Am I correct in that?
Andrew, once you get the BAT assessments from David, you will see there is no formaldehyde scavenging added to the WESPs.
This no longer happens. Okay, thank you.
So it's never happened. And due to the risk to the WESP, we won't be considering that as an option.
Okay.
I understand. I think what I understood was that the WESP didn't just take wood materials, it also took things like glue. And I take it that's because there are recycled wood going through here, things like plywood that might contain wood. Is that or kitchen worktops and that sort of thing? Is that correct? Is that where these materials might be coming from?
It's an element of the potential inputs from the post-consumer wood is all sorts, paints and other resins and glues, just like the particle board that's manufactured from the facility in the first place. But I believe the primary source of glues and resins in the emissions are from the press process, the actual additive of resins for the manufacturing process. Those emissions are extracted and vented to the WESP for abatement.
I see.
Can I come in on this point, please?
Yes, please.
I just want to make the point that there's a misunderstanding here. The vast majority of the formaldehyde that ends up in the waste gas stream is naturally occurring. It's coming from the wood. It's not coming from the resins at all. At least 50% of the historic formaldehyde resin use in Cowie PB is no longer happening. And very low emission source resins are used these days. So we're reflecting an ancient idea, but the vast majority of the formaldehyde is what's actually driven out from the wood in the drying process. It is a VOC. It's a volatilized, volatile organic that's driven out by the heat process, but it's coming in the main by majority from the wood itself.
Okay, thank you. Should we move on to the second bullet there? So what's the practical implications if the WESP crumb is found to be waste? I think this is something we've touched on, and about it seems that what SEPA would like is for the Cowie facility to apply for a permit as a waste incineration or co-incineration plant, and this is something that's resisted by the appellant. So there are presumably downsides to that, and I suppose that's what I'd like to get a better understanding about. But if I come to you first, Mr. Muir, on this bullet point, please.
Yes, and the brief points that I've chosen to make in the note are obviously that if it's found not to be a byproduct but to be waste, then prima facie it will simply continue to be shipped to Southampton for off-site disposal by way of incineration. I've made the point here that I've just made orally, which is obviously that the process under the HEP is a combustion process. It's not an incineration process. So certainly at the moment, I don't understand that in engineering or performance terms, the heat energy plant could be regulated as an incinerator under Chapter 4 of the Industrial Emissions Directive. And I've referred to Dr. Acton's affidavit at paragraphs 15 to 26, including the concern that if it was incineration as waste at a high temperature, then that would have adverse environmental impacts in itself. But effectively, the issue is that we have a combustion plant here, and if the crumb is found to be waste, then it will not be used as a fuel in that combustion plant. Whether there's discussion down the line about whether the kind of facility could or should or wishes to have a separate form of permit to deal with waste crumb itself is, I think, not really something that this appeal can really consider or determine, nor indeed is it really relevant, I don't think, to the strict question of fact and law under A, B, C, or D of Article 5.1. But it may be that Liz and Norbord wish to add something to what I've just said.
Thank you. Does anybody, Mr. Lindors, Mr. Roebuck, want to add anything now, or should we go to Ms. McGregor? Ms. McGregor, then, do you want to address this bullet point, please?
I think we've already covered some of the implications that we say would arise. Well, first of all, it would allow the controls of the emission levels. It would allow continual monitoring. Mr. Sullivan spoke this morning as to the anticipated plant upgrades that might be necessary in order to meet the technical requirements of Chapter 4, and that would involve probably better abatement systems to remove the lead rather than simply controlling the emission levels of lead. Mr. Sullivan, I don't know if you want to add anything to what I've said there.
Nothing to add to what I said previously about that.
I will just say one thing, and it's not about adding bits of kit onto the end of what's already there. If we're talking about incineration, we'd have to build an incinerator.
And that's presumably a major and expensive task.
Absolutely.
If it's just on the engineering side, the difference between the combustor and the incinerator or co-incinerator. A co-incinerator has to have two combustion stages. Primary combustion, where the waste is destroyed, and then secondary combustion, where you're required to hold temperature, oxygen level, turbulence for a defined time. And this is the point. That makes no difference to the lead generation rate. It actually makes it worse. So the HEP plant cannot be engineered to work as a co-incinerator. If SEPA are considering leaving it as a combustor, but with improved back-end abatement, then there are options there, but they're expensive retrofits.
Yes, now Ms. McGregor, you suggested that the Chapter 4 route would allow for controls of emissions, but can emissions not be controlled via this permit through? I mean, we're coming on to discuss conditions, but would it not be possible to set some limits the amount of lead that would be emitted, and then the way that was achieved could be by some new back-end piece of kit, as described by Mr. Acton, if that was the only way to meet these strict levels. But would that not be a possibility?
Andy Sullivan, do you want to tackle that first?
I mean, I think it would require a slight bending of the of the regulatory framework there. But I do take Mr. Acton's point there that that if the that perhaps not all aspects of Chapter 4 would be necessary in this case. But that's not what's been applied for here. So there's been no sort of application here to reduce emissions and to manage heavy metal emissions in this kind of way. It's simply to disperse them at greater mass emission overall. So we've not been in a position to try and consider how that might be done.
I understand, thank you. Right, any further comments on that bullet point then? And then come on to the third bullet point about the wider environmental impacts. We touched on this earlier and about how relevant it was to my consideration in this case. And I've taken on board the points about the lorries travelling to and fro to Southampton and so on. But Mr. Muir, do you have anything further to add on this bullet point, please?
No, I don't think so. The points made in the technical statement of Mr. Lindors and indeed in Mr. Glenn Campbell's statement explain the environmental impacts of the current arrangements, including the necessity to purchase and use gas imported to the site, and obviously the impact of the vehicle movements. In terms of the broader impact, in my submission, Norbord have made the case for reusing the byproduct here and for what they will save in environmental terms, quite apart from financial terms, but environmental terms. And this approach, this application, therefore, does seem to me to be supportive of the broader policy context where you seek to reduce generation of waste, you seek to use substances profitably where you can, to avoid having to classify them as waste, which is obviously the least good for the environment in many ways. But those wider environmental impacts are there for the reporter. They're, I accept, difficult to put a precise quantity on, but there is no doubt that there are advantages environmentally to what's being proposed. The disadvantage, which SEPA point to in legal terms at least, is based upon the air quality level, which again is addressed by Dr. Acton, and there's no risk of that being surmounted. The question is, how does one weigh up the environmental advantages? As I say, all of the evidence that Norbord has produced suggests that there is an environmental saving here that furthers environmental policy, but I can't put a precise quantity upon that.
Ms. McGregor?
Yes, thank you. Not much to add to that, other than I suppose we take a different view in relation to the environmental impacts of the process that's being applied for under this variation. We think it has an adverse impact on the environment, the release of heavy metals into the emissions and into the atmosphere. But the only other point to point out is one we made at the outset. All the affidavits and the material you have is focused on the transportation of this material to Southampton. And as we've already indicated, Southampton does not appear to us to be necessarily the only facility that could take this waste. So insofar as greenhouse gas emissions from lorries and transportation form part of that wider balance that you are looking at, then we ask that you bear that in mind.
So just on that point, if I may, there's been no evidence to suggest that there's some other plant that, or that Norbord is unnecessarily spending money to send the West Crumb to Southampton. The evidence is only come from Norbord about that, and it would be difficult, I think, for the reporter to reach a conclusion on that evidence that somehow Norbord are wasting their own money at the moment. But I'll leave that for you.
I probably will be able to conclude that the transportation of the West Crumb by lorry off-site, however far, will cause some emissions from the lorries.
Yes.
Right. Yes, I'm not sure how relevant the wider environmental impacts will prove to be, but I'll need to think about that in writing my decision. Any further points on this? Now, the next one about SEPA's concern, perhaps Ms. McGregor, I'll come to you first on this one because it's really a question directly for you. So, yeah, the question I posed there about whether your concern is essentially a technical one about the correct classification of the product, or whether there are real concerns about the environmental and/or human health effects of burning this material at this facility. I think we've possibly touched on this already, but I'll let you answer in your own words.
We have touched upon this, and we say it's not just a technical issue. I think we have expressed that we do have a concern. There are real environmental and human health concerns. We've said before that this site is already the highest emitter of lead in Scotland, and the variation, whatever form it takes, whatever ratio is chosen, would lead to an increase in that mass emissions. And we've already referred to the WHO guidance on lead emissions and the statements made there. We do say that it's important to get the classification correct. It's a point we've made a number of times today, because only when you get the classification correct can you apply the correct regulatory framework and the controls that apply with that framework. You talked earlier with Mr. Sullivan about conditions. I think there are some real concerns about whether conditions could be appropriately applied to this permit, and certainly no conditions have been suggested by the appellants. You touch on conditions later, so I won't go into that in too much detail now, but I think the key distinction between the West Crumb and the other production residues for us is the high metal content. We keep coming back to this. It does differ in composition from the other input materials, and the information that has been presented to date suggests that it can only be used if it's diluted down. But even if diluted down, the mass emissions of lead still increase. So yeah, in summary for us, and I'll then pass over to anyone else in SEPA if they want to add, it's not technical for us. There are real concerns.
Thank you. Does anyone else in SEPA want to come in on that?
No.
Okay. Turn to you then, Mr. Muir.
Yes, just briefly, SEPA's concern is expressed in a by reference, I think, only to the legal requirement on air quality, which is the one that Dr. Acton addresses in his affidavit. when it comes to the WHO fact sheet, that of course is not a lawful requirement in the United Kingdom, and we're well aware about the need to monitor heavy metal emissions, and indeed that's what the purpose of the emissions test was. So insofar as the condition requires, the fourth condition requires one to look at what is lawful or not. As I say, the concerns about whether there's a slight increase or a decrease in the heavy metal emissions is not something that's within the reach of the air quality law as such. The only other point that I'd make is to mention the, as we do in our speaking note, the relevance to the reference to the quarterly testing of emissions and the checks that do take place already under the permit, and also to mention the reference to our note of the 16th of July, but I think we've probably covered those already. So in terms of the Industrial Emissions Directive, that does seem to be one of my classification, but as I say, for the reasons I've given, it's not directly relevant because that concerns waste incineration, and you have to answer the overall question in Article 5 before you can be clear that you're dealing with waste and not a byproduct. So I think that's all I need to say about 6.4.
Thank you, Ms. Armstrong.
Yeah, if I could perhaps just come back on that point, since it has raised again about the lawfulness. And I mean, I wouldn't repeat everything that's in our submissions, of course, but I think just referring back again to the European Commission's guidance, and albeit it is only guidance, but it is very much guidance that was produced after the Waste Framework Directive and very much to guide authorities such as ourselves in these difficult issues of definition of waste. And really just the guidance that provided in terms of Mr. Muir has raised the point about that we are presupposing that it is waste in the arguments over that it was then special waste and the restrictions under the Waste Framework Directive and how we deal with that. But the guidance does say that in looking at the lawfulness, we can also look towards whether an indication could be gained from assessing how it would be used and treated under provisions of waste legislation in order to prevent these adverse effects that we are concerned about. And so really that is where it comes in about looking at how it would be treated if it was defined as waste. So I don't think it's irrelevant to dismiss that argument, and really looking at the need, as we have discussed, for the Chapter 4 controls on waste incineration, were you to burn it under those provisions. So just to bring in again that comes from the European Commission guidance, and that is really where we have based that as well.
Thank you. One question I had possibly for Mr. Simpson is, if I were to allow the appeal and the West Crumb were to be burnt on site, and we've heard that there is currently quarterly monitoring of the emissions at the plant. If that monitoring showed that lead levels were unexpectedly higher than expected in Mr. Acton's analysis, or even approaching the UK air quality standards, is there action? What action could SEPA take in those circumstances, or would having the permit having been granted, would that tie your hands? I think you're on mute, Mr. Simpson.
Excuse me, Mr. Poor. If the permit was varied to require an ELV for heavy metals in the combustion gases and the extracted emissions, the if the ALV were breached, then it'd be a breach of condition, and where SEPA could take appropriate enforcement action upon the operator. My only concern really is that there's two extremes when if we're trying to incorporate what would be under an incinerator type permit into this process. That you've said there, you know, quarterly environmental monitoring. We've already touched on the variability of the CRUM and this blend ratio and everything, and that we'll never really have a great understanding from the information we have as to what this sort of emissions can be. But if we then take that down to a quarterly monitoring, and we only go in there every 3 months and look at the results, then I don't think we'd have the greatest confidence in when we compare it to the controls under a waste incineration process, primarily because a waste incineration permit would require continuous environmental monitoring systems on the stack. So they could look at it instantaneously or daily and see those fluctuations and see those variations in real time and take appropriate action to ensure the emissions are compliant and, most importantly, safe to the environment and human health. So it wouldn't simply necessarily be an ELV that would achieve that. It would have to also include some sort of more stringent monitoring.
So ELV stands for?
Pardon me, an emission limit value.
And even if there wasn't a condition, if there was no condition, would that, would the granting of this permit or this amendment to the permit allow any amount of lead to be emitted, or is there still some sort of backstop if levels were very high?
No, it wouldn't. Air quality modelling, such as Dr. Atkin has provided for the appellant, is not something that we require frequently under the existing permit. It's more a state of change in the process, then we would look at that. But that's ultimately why they included that in the application. There would be no other information to tell us what those metal emissions would be unless there was monitoring and, of course, ELVs associated with that. Now, there is monitoring already undertaken for metals, as has been mentioned, but that's an annual requirement. It's not frequent, and it's certainly not continuous as is best practice under normal waste incineration processes.
So yes, Mr. Reporter, I think that there would be no limit on the amount of heavy metals that they could release if the variation was granted as is.
Excuse me, something could be done there, because the lead we're talking about is a fume, so it's in a solid state. So you can put continuous particulate monitoring, dust monitoring, which would work as a surrogate for lead. You could then do your MCERT's non-continuous monitoring on a, say, monthly basis instead of quarterly, and cross-reference the lead content to the total dust release, and therefore you would have an indication of whether the lead is staying in the same level, going up or going down.
But that would need to be something that I secured through a condition, which we're coming on to talk about.
Sorry, was that back to me?
Yes, I suppose
Sorry,
so.
I
Yes.
didn't hear it. Carrie, can you go again, please?
Well, your suggested course of action there would need to be something that I secured by a condition.
It would indeed. Yes. Yeah. The point is, you can't do a continuous monitor for lead. You have to do an extractive sample, then have it analysed offline. But as I say, dust would be a surrogate for that.
Thank you. Any further points. I'm conscious of the time. We're quite near the end of the agenda, so I'm happy to press on. But if anyone wants to have a short break now, then I'm happy to. Press on. Yeah, press on. Other than further matters, we'll come on to talk about conditions and the site inspection. But apart from that, are there any other further matters that anyone wishes to raise regarding this appeal? No. Then let's talk about conditions then. And in the event that I find in favour of the appellant, I would need to consider whether any additional or amended conditions would need to be applied. Mr. Muir, are there any such additional conditions that I would need to think about?
Well, we've referred in the speaking note to the possibility of conditions, and they're mentioned in Dr. Acton's affidavit of the 8th of January 2021, paragraph 20, and again at paragraph 23. And it's probably sensible that you hear direct from Dr. Acton if there are any questions about what he proposes there. But ideally, I think Norbord would anticipate that if user reached the conclusion that West Crum is a byproduct, then conditions may well simply be capable of agreement between SEPA and Norbord. But it may be that you would wish them to seek to agree matters, or that you would have particular points that you would wish covered by the condition, but the precise wording of it would be something best dealt with at a technical level between SEPA and Norbord. But in principle, there's no objection to a condition of the type that's discussed by Dr. Acton being included.
Would that be competent for me to leave things open-ended like that, or I mean, certainly in a planning case, I would have to set out the conditions myself in my decision.
Yes.
I was thinking what alternative approach might be for me to ask yourselves and SEPA to go off now and agree a possible set of wording and come back to me in a couple of weeks with a set of wording, obviously not prejudging my wider finding on the appeal as itself, but only in the event that I were to find in your favour. And if you could come back to me with an agreed set of wording, or even a set of wording, alternative sets of wording, or a set of wording with notes of disagreement attached to it, and that can be done inside a couple of weeks, say, then that might be a better way forward.
Well, I was about to suggest that, so I'm grateful to you for that. That seems to me subject to any comments that Norbord may want to make, and I see Mr. Roebuck's hand is up, but that seems to me a perfectly plausible way forward that assists user before the point at which you need to determine the appeal.
Thank you. I probably do have a question for Mr. Acton, and I'll come to Ms. McGregor, but Mr. Roebuck first.
Yeah, just speaking for the company, we don't have any objections to conditions being created jointly about how to control this process. Everybody is well aware of the difficulty of continuous measuring of wet gases. It can't in reality be done. The concern here is the amount of material. So the simplest condition, given that we have already committed to install specified monitoring equipment in terms of addition rates or control screws, would be to insert a condition about use rate, addition rate of this material in the fuel. That would be the simplest, easiest to measure, I think, and it could be done continuously.
So by use rate, you mean like the proportion of West Crum that's going into the mix?
Yeah, for argument's sake, if you say, well, it'll be 2.5% of the total fuel bill, that's or a mass, kilograms per hour. Both of those things are inherently measurable, verifiable, and controllable, and relatively easy to do.
Ms. McGregor, your comments on conditions?
Yeah, I don't want to prejudge the discussion, so I think if the consensus is that we should go away and we should discuss what conditions might be appropriate, then SEPA would be happy to participate in that process. I suspect, though, that the conditions that we would be looking for are well, far more in number than those envisaged by Norbord. For example, we don't envisage that a simple condition controlling use rate would be sufficient to achieve what we need it to achieve. We don't have the confidence that simply applying a use rate would allow us to control and monitor and regulate emissions in the way we want. But I don't want to close down that avenue of discussion. If we think, given the time today, there would be merit spending some time to see if we can reach an area of agreement or set out areas where we can't agree, then I'm happy to do that.
Okay, I think that would be my preference. My general comment would be that I prefer conditions that get to the heart of the issue of concern. And if the issue of concern is lead emissions, then that seems to be the ideal thing to address. But then if maybe that's very difficult to do, and then some sort of surrogate or other approach may be the only practical one. I think that probably, I did have a question for Mr. Acton, but I think it's probably been overtaken by that discussion. I think if both sides are happy to go away and talk about conditions, I mean, I think I'd envisage ideally a single submission. I'm not bothered who it comes from, whether from the SEPA side or perhaps if it comes from the appellant's side. If we said does close of 2 weeks today, does that sound doable? And as I say, it can note any disagreements or alternatives within it. Often I see these things presented as a table with the appellant's proposal, then SEPA's comments next to it. As one possible approach. So if you're happy with that timescale, I'll leave that as an action then, and I'll ask Ms. McComsky to circulate that as a note. Ms. Armstrong, did you have your hand up there?
Yeah, I was just going to raise my concern really about trying to agree conditions between us over the course of 2 weeks, given that without the conclusion on the definition, I guess a lot of perhaps what we would be looking for would be relying on controls around Chapter 4, which come from it being as waste, and it was just really the extent to which we would be able to reach any agreement on appropriate controls. Just to say there is a lot of technicalities there around the appropriate limits and the monitoring that could be put in place, and therefore I think there could be difficulty in reaching an agreement on that, but as we would certainly consider that, obviously, but there might be a lot of technical issues that would require input that wouldn't be achievable in 2 weeks.
Right. It wouldn't be achievable in 3 weeks either. You mean it's not a question, a detailed question of.
It still comes down to the crux of the issue, doesn't it?
Yes,
whether we're regulating it as a waste or regulating it as a byproduct, and what are the appropriate controls to put in place. So
yes, I mean, this is all in the scenario where I find in the appellant's favour and allow the appeal, which of course I'm not prejudging at all. I would expect SEPA to approach the question in that way, and certainly any agreement by SEPA to conditions, I wouldn't take that as any sort of indication from SEPA that they're relenting in any way on their approach to the wider appeal.
Okay.
But certainly, I mean, if at the end of the day parties find it easier, or there's so little overlap in your positions that it makes more sense to make 2 separate submissions, then we could go down that road. I suppose it's certainly preferable for me to have a single submission, because then I don't need to be asking the other party for comments on the first party's submission. So I think I would rather have a single submission but that notes disagreements within it, and that the making of the submission is agreed by the two parties.
Perhaps 3 weeks would be slightly wiser then, given that there may be a bit of to and fro between the parties if there's to be a single submission. I don't know if Mr. Lindoris has his hand up, so I don't know if he's wanting to make a contribution on this.
Yeah, thanks, James. I just wanted to go back to Miss Armstrong's point, and it was put in as part of your submissions, James. If the appeal goes against the company and yourself, Mr. Hall, deems the products a waste, we are going to be continuing disposing of it off-site. So really, if you're looking at conditions, it would have to be if the appeal goes in the favour of Norbord and it is a byproduct. So really, I'll go with Miss Armstrong's point there until we have a decision whether it's waste or byproduct. There's not a lot we can do. If it's waste, it gets transferred. The only thing would be if it goes in our favour as a byproduct, then we can look at conditions.
Well, I think, sir, your proposal was that you would wish to make a single decision at one point in time, which would include a condition to be imposed in the event that your judgment on the principal point was that it's a byproduct, and that you would prefer to have that condition agreed between the parties on that hypothesis in advance of issuing any determination. That's what I understand your position to be, and if that is the position, then I imagine parties will be willing to spend a little time on that hypothesis that it is a byproduct to look at how that might be conditioned. That change.
That's right. I think that's a fair summary. So we're at 31st of August now. If we said, I mean, I have an Edinburgh holiday on the 17th and 20th of September. So if we were to say the 21st of September, that would be 3 weeks from today. If I could ask for that submission to be made by that date, please. So if we can move on to the final item, which was a site inspection. I note from Mr. Muir, from your notes, that the appellant doesn't consider any site inspection is required. That certainly reflected my initial thinking. I'm not sure how much I would gain by seeing machinery that I'm not really familiar with in situ. But do you have anything more to say on this, Mr. Muir, or to add?
I don't think so. You have photographs of that indicate some of the sources and the trial. You have process maps and diagrams, and you've got the descriptions. If there's anything that you feel that you need in addition, obviously the appellant's very happy to assist. But it didn't seem to us that it was a case that required you to see something in person to reach a determination.
Ms. McGregor, SEPA's position on this?
We were happy to leave it to your discretion.
Thank you. Well, as I say, I don't think, from what I think I've got the information I need in terms of visuals and so on. So I don't identify a need to do a site inspection. So I think that brings us to a close. If nobody's got anything further to add, I'd just like to thank everybody very much for their participation today, which has all been very helpful and clear and carried out in the proper spirit. So thank you very much for that. As I say, I'll issue a formal request for that submission later in the month. But beyond that, I should say thank you very much and good afternoon.
Okay, thank you.
Thank you.
Thank you.
Thanks.
Thank you.